All right, ladies and gentlemen, if I can have your attention, please. I'm pleased to call to order the 120th meeting of the Massachusetts Gaming Commission, about 1 o'clock, 1:05, in our customary location at the Boston Convention Center. Before we start, I want to read a statement. I've said repeatedly over my 2 years as chair of the Gaming Commission that the single highest priority for our work is that we protect the integrity of the decision-making process. And I've also said repeatedly that the appearance of integrity, as well as the reality of integrity, is critical. Over the past several months, my behavior and my judgment concerning the parties to the Region A decision has been questioned, sometimes in good faith, sometimes in bad faith. Frankly, neither I nor any of the commissioners have any doubt about my ability to be impartial in the decision-making process. But the compounding of these issues has now gotten to the point where my participation in the decision-making process has become a distraction and a potential threat to the critical appearance of our total impartiality. I want to take this opportunity to note the extraordinary amount of hard work and dedication that's resulted in the considerable progress and accomplishment achieved by the Commission and by our staff since we embarked on the implementation of an incredibly complex licensing process and the establishment of a new state agency. I will not allow anything to distract or to discredit all of that comprehensive effort. Therefore, I've decided to recuse myself from any further involvement in any of the issues concerning the licensing decision for Region A. For those discussions, Commissioner Jim McHugh will act as chairman of the commission, and my decision will have no impact on the schedule for Region A. In all other respects, I will continue to serve in the role as chair of the Gaming Commission, and I look forward to being a part of its ongoing and important work. With that.
Well, Mr. Chairman, I understand why you're doing this. I regret the need that you perceive to do this. I said before, and I say again, that I have no doubt whatsoever, having worked with you extensively over the past 2 years on a daily basis, in your ability to be impartial, in your focus on the best interests of the people of the Commonwealth, and the effort that you have made to bring the Commission to where it is today, and on your visceral belief in the the necessity to achieve the goals the legislature so carefully set out in the legislation. I understand why you're doing this. I regret the need that you see to do this, and we'll move on in your absence.
Thanks very much. We are going to take a very quick break while the temporary chair gets organized, and we will reconvene with 4 commissioners in just a very few minutes. Thank you all very much.
I'd like to call to order the meeting. And proceed with the agenda that we've set out for today. The first item on that agenda is the issue of the petition of the Wynn Mass with respect to the arbitration proceedings with the City of Somerville. General Counsel Blue, would you care to set that up for us, please?
Thank you, Commissioners. The Commission has before it today a petition for failure to participate in binding arbitration filed by Wynn Mass LLC against the City of Somerville. The City of Somerville has filed a response to Wynn's petition. Both documents are in the Commission's packet. The petition is filed pursuant to the Commission's Regulation 125.016. Both parties have been advised that the Commission will not accept further filings on the matter or take testimony today. However, representatives of the parties are here, and the Commission may ask questions of those representatives if it so chooses. Wynn's petition alleges that Somerville is failing to participate in arbitration because Somerville has proposed the appointment of an arbitrator to the panel of arbitrators that Wynn believes does not meet the neutral and independent standard required under Commission regulations. Wynn is requesting that the Commission order Somerville to withdraw its proposed arbitrator and appoint an arbitrator who is neutral and independent. The Commission regulations do not define neutral and independent. The Commission's arbitrator handbook, however, requires each arbitrator must be neutral and independent, free of bias and conflicts of interest, and capable of discharging their responsibilities within the expedited schedule required by the Gaming Act. Arbitrators who live in the surrounding community or who have any current financial or business interests in the applicant, the host community, or any of the applicant's surrounding communities are not eligible to act as arbitrators. The arbitrator should disclose to the parties whether they have or have had any ongoing or past financial or business interest in the applicant or its qualifiers, the host community, the surrounding communities, or any law firm or consultant representing any of them. The arbitrator should also disclose any relationship, experience, or background information that may affect or appear to affect the arbitrator's ability to be impartial and the party's belief that the arbitrator will be able to render a fair decision. Under 205 CMR 125.016, in the event that a community fails to participate in the arbitration process, the Commission may deem the community to have waived its surrounding community status. Under Section 1 of Chapter 23K, the Commission has ability to construe the power and authority granted to it as broadly as necessary for the implementation, administration, and enforcement of Chapter 23K. This grants the Commission the authority to provide a remedy to address the matters raised in the petition, and the Commission is not limited only to the remedy of deeming the surrounding community designation status as waived. The case law in Massachusetts follows generally the federal case law on the standard for disqualifying an arbitrator based upon bias. The case law requires that evidence of bias must be direct, definite, and capable of demonstration, not remote, uncertain, or speculative. Federal case law says that arbitrators are not held to the same standard of impartiality as judges. The parties have provided in their filings their arguments as to why or why not Somerville's proposed arbitrator is or is not neutral and independent. The Commission, after review of those findings and deliberation, can render a decision regarding Wynn's petition and, if necessary, fashion an appropriate remedy.
All right, thank you very much. Are there any questions for Counsel, General Counsel Blue? At the heart of this is a single arbitrator, Mr. Foy, whose impartiality has been questioned by the Wynn interests, and it is at his qualifications to serve as an arbitrator, because of his past relationship with the city of Somerville, that petition is directed. Do I summarize that issue fairly?
That is correct, yes.
All right. And his relationship with the city of Somerville, his past relationship, is a part of the record today, the meeting packet that's available to everybody. And I've looked at it. I'm sure all the other commissioners have looked at that. The arguments of counsel on both sides are there as well. So I guess I would begin by asking whether there are any questions. I guess I already asked that question of General Counsel Blue.
To your point, Commissioner, about the prior relationship, it has two elements, doesn't it? There is, Mr. Foy has participated in the past doing some work for the city directly and getting compensated, although there is not a current relationship, if I'm not mistaken.
That is my understanding from what was filed, yes.
But there's a second element too. Mr. Foy did participate in other capacities in relative to the Assembly Square task force. Remind me the right name of that.
I believe that's what it was, yes, he did
Right.
participate.
Well, he participated as a mediator between opposing interests with respect to Assembly Square, according to his resume, if I'm reading that correctly.
I think that is correct,
Yeah.
yes.
And so he was not a partisan in that. He was an impartial mediator in that instance. And the record is clear that he says that he has no continuing current interests or arrangements with the city of Somerville.
And nor does he live in the city.
That's right, he does not live in the city of Somerville. He did disclose that he has a son that lives there, but he himself does not live there.
And that standard for the arbitrator is slightly different than that of a judge, as you explained to me. There is not the same standard. Is that, this is just not the same, the level of what would be considered neutral and what would not, or slightly different?
It is a different standard. Judges have a much higher standard of impartiality. The understanding with arbitrators is that they tend to be business people. They are involved in the market in which they work or function, and that they will certainly have more knowledge and more contact with the market in which they work.
But if the past few minutes are any indication, this commission and this whole process is held to quite a large standard, right? Quite a high standard, I should say.
It is. There's no question about that. The question is not, though, the commission's standard for self-governance. The question is what is to be expected from an arbitrator whom one of the parties hires to be part of the the arbitration process. And I think we don't want to blend over and impose a different. Well, that's something to discuss. We don't want to necessarily impose different standards on arbitrators than normally the standards require. We've set out in the handbook what the standards are. That's there. We haven't articulated what those standards are in the past in any detail that focuses on a specific individual. But it seems to me we ought to be think carefully about imposing standards that we have on arbitrators.
And certainly this, the reason for a third arbitrator would be because there's not total consensus with either one or necessarily the two that were selected by both sides. So the third arbitrator, there needs to be a consensus or the commission gets involved.
Our regulations provide that the parties can agree to go with a single arbitrator. They have not agreed to do that here. They are going with a panel, so the commission could, say that each arbitrator that's been proposed will follow the regulations and potentially pick a third arbitrator. In the case where a third arbitrator can't be agreed to by the parties, the commission can designate a third.
Let me say that I see two issues here. I see one of substance and one of disclosure. And I want to. We haven't talked about this before, but there may be other instances in which this same issue is going to arise. There are situations in which the arbitrator chosen by each side in a three-party arbitration situation is not neutral. And there's a whole way of dealing with that, a whole process for arbitration that involves that. We have set out in our regulations, however, that neutral arbitrators are required. So the question is, what is a neutral arbitrator? And a neutral arbitrator is one who is able not only to be neutral with respect to the issues, but neutral with respect to the process. And it seems to me that, and I'm going to get a little legalistic here for a second and quote from a decision from the Supreme Court of the United States that I thought was particularly helpful. It's a concurring opinion by Justice White in an old case, was decided in 1968, in which his vote and that of Justice Marshall was necessary for the decision. So it's an important concurring opinion. And he said, the court does not decide today that arbitrators are to be held to the standards of judicial decorum of Article III judges, or indeed of any judges. It is often because they are men, it says, but men and women, of course, of affairs, not a part, but of the marketplace, that they are effective in their adjudicatory function. It means that arbitrators are not automatically disqualified by a business relationship with the parties before them if both parties are informed of the relationship in advance or if they're unaware of the facts but the relationship is trivial. I see no reason to automatically disqualify the best informed and most capable of the potential arbitrators. Massachusetts law follows the same theme. That is a theme that initially looks at disclosure. And I find that most of the cases in which an arbitration award has been upset because of lack of impartiality are cases in which there's been no disclosure up front. Our handbook talks about disclosure. The ABA Code of Ethics for Arbitrators says, and I'm going to quote again, that if an arbitrator is requested to withdraw by all parties, the arbitrator must do so. If an arbitrator is requested to withdraw by less than all the parties, because of an alleged partiality, the arbitrator should withdraw unless either of the following circumstances exists. The first doesn't apply, but the second does. In the absence of applicable procedures, if the arbitrator, after carefully considering the matter, determines that the reason for the challenge is not substantial and that he or she can nevertheless act and decide the case fairly and impartially. That ties right back to Justice White's approach to this process. The arbitrator first decides whether he or she can approach the process fairly and impartially. If he or she can, then there's an opportunity perhaps for a second look thereafter. One may wonder why an arbitrator would want to get himself or herself into a situation in which the stability of the resulting award would be less than ideal. But be that as it may, the process looks at an arbitrator first deciding whether he or she in fact can proceed and articulating the reasons for that decision, and then moving forward to see what results from the arbitration proceedings. That ties in with the approach we've taken in our arbitrator's handbook. So I think that for me at least, the disclosure piece and then the ultimate results piece are both important. And that's how I look at how we weave our way through this.
One thing, though, our process has this arbitration be, for many reasons, has this the decision of the arbitrators to go with one or another of the best and final offers. There were many reasons, expediency was one of them, that we decided to set that up. So the arbitrator or arbitrators don't have a lot of leeway in terms of negotiating or trying to come to the most optimal solution,
right,
which strikes me would be the model under all of everything that you just read clearly applies. My question is, given the way that we have set up this arbitration process, is there a higher bar as we think of these disclosures or expectations of expertise versus neutrality that we need to consider?
Well, we certainly should consider that. That's an important consideration, but it's also important to keep our eye on the ball. And the ball here is a motion to find that Somerville is not participating fairly in the arbitration process, I'm paraphrasing. But that's because it's appointed an arbitrator, because it's appointed Mr. Foy to be their arbitrator. So that's the ultimate focus. And it seems to me that framework for analysis, whatever the ultimate result is, does come into play in deciding the answer to that question. That's a little legalistic, but a lot of things can happen during the course of the arbitration. And the preference is, it seems to me, and I would advocate that our preference be, to let it run its course with the disclosure. Mr. Foy may say, after taking a second look, he doesn't think he can fairly participate or should fairly participate. That's entirely possible. He may participate in the decisions unanimous. A lot of things can happen in the process. And, but the established way of proceeding in this area is to let the arbitrator have the first crack at deciding whether he or she should participate.
I thought he had already done that.
There is in your packet a disclosure form that he filed where
Right.
he did indicate he believes he can participate and be impartial and fair.
So if that's so, it seems to me that needs to be on the record or made part of the record of the arbitration proceedings, and then they go forward, unless we decide to cut it off now.
Commissioner McHugh, that was very helpful. Very helpful to me to hear it in a direct sense with a very similar process to what we're engaged with here. And I'm persuaded and comfortable that we can move forward, that to make the determination that he is not neutral. I think the standards have been met, And I'm comfortable moving forward, and there'll be a third arbitrator.
I'm comfortable with moving forward as well. I'll keep my fingers crossed as to whether we can find let the two parties find the third arbitrator.
Well, we could decide that we could appoint the third one ourselves, could we not?
Only if we conclude that they're not they're not participating in the process. Isn't that right?
We would give them an opportunity to try to do that first. I would suggest a certain number of days to pick a third, and in the event they can't, then our regulations allow us to pick the third.
Yeah, but, yeah. Right.
I mean,
If the two are at an impasse, then we
Yes.
can step in, that's right. But I mean, we don't have the ability just to jump in right now
Right.
and pick a third arbitrator.
Is there a certain number of days that kind of fit within our schedule, within the Flex 14 that they have the window to operate in, that we would suggest, not suggest, but give them a tight time frame?
The regulations talk about 5 days, so we would suggest 5 days for the two arbitrators to pick the third arbitrator, and then to come back to the commission if they're unable to do that.
Sounds like a reasonable window.
I think it's important to let the process work out. Hopefully, they'll be able to decide, and if not, then we'll do that.
I will disagree, but sounds like it's a 3-1 decision.
All right, so I would move that, I think we really exhausted
Yeah, we have.
the issue here. So I'd move that the petition of the wind interests to determine that Somerville has failed to participate in the surrounding community arbitration be denied for the reasons set out in the discussion that we've just had. Is there a second to that motion?
Second?
All in favor?
Aye.
All opposed? All right, the ayes have it 3-1. And the objection, of course, of the wind interests to that decision is noted. The rights, such as they are saved.
Commissioners, I would ask that you approve a delegation of authority to staff to appoint the third arbitrator in the event that the parties are unable to do so.
I would move that the commission grant our general counsel the authority to appoint a third arbitrator if within a 5-day window the two parties cannot agree on a third arbitrator.
All right, any discussion on that? Now, this would be, yes, there is discussion on that. Mine. This would be after you got notice of an impasse.
That's right. And it would be for this particular situation. I would not ask the commission to make this as an overall grant at this point, but in this situation, given our meeting schedule, it may be helpful to keep the process moving if we do that.
And obviously, we would urge the two to pick an agreeable third. Okay,
Yes.
I got it. Any further discussion?
No, I think it would be very helpful if we grant that authority, given our meeting schedule and the need to move it expeditiously.
Okay. So there's a second for that motion, is there?
There is,
And any further discussion? All in favor?
Aye.
And so delegation to the general counsel to pick a third arbitrator in the event that there is an impasse between the other two is approved. That brings us then to items 4 and 5 on the agenda, and item 4 calls for the commission to determine the premises of the gaming establishment for which Mohegan Sun, Massachusetts.
Mr. Chairman, we have item 3, the Flex 14 update. I think it'll only take a minute or so to.
Yes, I wanted to
And Mr.
move ahead
Ziemba
too
will.
quickly, didn't I?
Mr.
Yeah.
Ziemba
All right.
will present
Mr.
on that.
Ziemba.
I think I can constrain myself to 1 minute, actually.
Good.
I'm pleased to report that what we are calling the Flex 14 plan has proved to be a very beneficial tool in helping parties enable themselves to resolve a number of different issues regarding timetables, regarding ability to continue to negotiate all or soon to be all of those parties that are in arbitration will be utilizing Flex 14 within a matter of days. So in regard to that tool, I think that that's been a really beneficial one. In your packet, there is a proposal by Council Blue and I to provide further flexibility beyond that we've already granted. As commissioners know, we have the ability to add 14 days to the schedule to allow parties to conduct their arbitrations, to continue negotiations, but there's a subset that has come up in recent days that wasn't contemplated in the memorandum that we put before the commission. And notably, even though the parties can extend their arbitrations by 14 days, there's nothing specified in there regarding the deadline for the filing of the fundamental inconsistency petitions. And we believe that it would make sense for parties to be able to file those at a later date if they both agree, so long as that there is enough time for the commission staff to review those petitions in advance of the end of their arbitration proceedings, and as long as those objections are made before the conduct of any hearings by the arbitrators. As we've seen in the Western Mass region, the FIPS objections had somewhat of a role in what was determined by the arbitrators. So as long as those two prerequisites are met, we believe we should have the further flexibility to provide that additional flexibility.
This would only be if both sides agreed, so one side couldn't shorten, in effect, the response time of the other.
That's correct.
Right. Discussion?
I think it's reasonable to add more flexibility to the flexible 14.
There is just one other thing that I'll note. We had some time constraints on when the parties had to notify us when they'll be utilizing Flex 14, and specifically for the stay of the beginning of arbitration, we had the day prior to the date for the selection of arbitrators and the filing of best and final offers. We don't believe that additional day is necessary if they cannot. If they need to do it on the actual day of the selection of arbitrators and best and finals, we would certainly grant it if it's in the interest of both parties.
All right, further discussion? Somebody want to make a motion?
I move to accept the changes outlined in the memo by Ombudsman Zamba and General Counsel Blue, amended on May 8th.
Second.
And the purpose, of course, is to give the additional flexibility that Mr. Zamba just described. All right, all in favor?
Aye.
Aye.
All opposed? Nay. The ayes have it, unanimous. All right, that does bring us to the items 4 and 5 on the agenda, and I want to just set the stage a little bit for those items. Item 4 calls for the commission to determine the premises of the gaming establishment for which Mohegan Sun Massachusetts LLC seeks approval in its RFA 2 application. Item 5 calls for the commission to determine the premises of the gaming establishment for which Win Mass LLC seeks approval in its RFA 2 application. I want to outline for a second the process that the commission is engaged in up to this point and some of the history that has brought us here today. That history and that process identifies some of the salient issues that face us in making these decisions. In creating the commission, the legislature granted to the commission all powers necessary or convenient to carry out and effectuate the purposes of the statute. Further, Chapter 23K provides that the power and authority granted to the commission shall be construed broadly and as broadly as necessary for the implementation, administration, and enforcement of the gaming law. To that end, the commission is empowered to define the premises of a gaming establishment. In accordance with 23K, Section 2, a gaming establishment is, and I'm quoting now, the premises approved under a gaming license, close quote, and a gaming license is, quoting again, a license issued by the commission that permits the licensee to operate a gaming establishment, end quote. Pursuant to Chapter 23K, Section 19, the commission is the sole entity with authority to issue a Category 1 gaming license, and accordingly, it's the sole entity with authority to determine what a gaming establishment is. Ordinarily, the commission would make that determination as part of the final award of a gaming license. Indeed, it has to do so because in the license, it has to set out what it is that it's licensing. In this instance, however, the City of Boston has filed a declaration stating that it is a host community under the gaming law as to each of the two applicants' premises in Region A, the Wynn premises and the proposed Mohegan Sun premises. Accordingly, the only way to address the issue is to advance the gaming establishment determination and make that determination for both of the applicants in Region A now. Of course, the licensing process continues. Issues, as we have seen, can change, and so nothing is final in a final sense until the license actually issues. But this determination that's before us today is one that's designed to set in place a series of steps, regardless of which track is taken, that necessarily need time in order to succeed. And so this determination is, when made, going to set the course for the immediate future and presumably for the end. By law, no host community determination can be made without first determining what a gaming establishment is. That's because the term gaming establishment is contained within the definition of host community. Specifically, the definition of host community in Chapter 23K, Section 2, provides that it is, and here again I quote once more, a municipality in which a gaming establishment is located or in which an applicant has proposed locating a gaming establishment, close quote. In order to determine where a gaming establishment is located, though, we must first determine what it is. Once the gaming establishment is determined, its evident location will organically lead to a determination as to what the host community or communities are. The focus of this hearing, then, will be on the term gaming establishment. The term is defined in Section 2 of Chapter 23K as, quoting once more, the premises approved under a gaming license which includes a gaming area and any other non-gaming structure related to the gaming area and may include but shall not be limited to hotels, restaurants, or other amenities. As it is frequently done, the Commission has solicited public input to assist its thinking as it makes these determinations. In its April 3, 2014 meeting, the Commission outlined the process by which it would take public comment. That process was designed to ensure that any member of the public would be able to offer input and comment in a fair but uniform manner. To that end, to ensure that the comments would be presented in a format that would be most helpful to the Commission solicited comments in the form of legal briefs that addressed either or both of the two questions posed. The initial briefs were due by April 17, and briefs were submitted by Noeasti Casino, Mohegan Sun Mass, LLC, Wynn Mass, LLC, and the City of Revere. The City of Boston submitted a letter discussing other issues, and all of these submissions were posted on the Commission's website. The Commission then allowed anybody who desired an opportunity to submit a reply brief by April 24. Those briefs were to be limited to the issues raised in one of the initial briefs. Noeasti Casino submitted a reply brief, which was posted on the Commission's website. Each Commissioner has received and reviewed each brief, as well as the reply brief. The process set out by the Commission provided that the City of Boston and the Region A applicants for a gaming license would be invited to offer an oral presentation to the Commission at today's public hearing if they had submitted a brief or reply brief. Both Region A applicants have submitted a brief and accordingly are invited here today. And although the City of Boston did not technically submit a brief or reply brief, they were invited to present today as well. The commission will also invite No Eastie Casino and the City of Revere to make oral presentations since they submitted briefs in the manner requested. Oral presentations by any group should be confined to the questions on the table today, defining the premises of the gaming establishment for the Mohegan Sun proposal and the Wynn proposal, and the content of the submitted briefs. Speakers representing a municipality or applicant will be allotted 30 minutes for their oral presentation. All other speakers will be allotted 15 minutes. The commission may allow speakers more time if it's helpful to clarify an issue, and the parties may split their time if they choose to do so. For purposes of the record of this meeting, the commission takes notice of the contents of the RFA 2 application submitted by Mohegan Sun and by Wynn. After the oral presentations, the commission will discuss each of the questions and make determinations as to what the gaming establishments are and where they are located. Effectively, this will resolve the inquiry raised by the City of Boston relative to its host community status. Shortly thereafter, the commission will issue written findings that describe the respective gaming establishments for the projects the applicants have proposed. Now, there's one other thing, and that is that last week when we postponed this meeting to today, it was supposed to be last week, as most people in attendance recall, we postponed it to today at the request of the city and the request of the governor supporting the city. And I said that we would make an effort to see to it, if we could, that the master lease agreement and the Wynn option agreement be posted on our website before today's meeting. I did that because there has been some discussion of both of those, and both of those documents had been granted confidential status at the applicant's request when the initial applications were filed. Under our regulations, the applicants therefore have 14 days to object after we make a determination that some parts of the documents are not to remain private any longer. Up until yesterday, both agreed, asserted those rights to take the 14 days to make the objection. Last night, as I understand it, the Mohegan Sun interests waived their objections, so that in mostly unredacted form will be published as part of the Mohegan Sun application tomorrow. The Wynn interests have not waived, as is their right, and so it will take a little bit longer to get that posted. The commission, however, has taken a look at both of those documents, and there's only one portion of the Mohegan Sun application that bears on the issues that face us today, and only one portion, at least in my view, that bears on the Wynn application today. The Wynn application piece was discussed at some length at our meeting of September 4, and so that's already out in the public view. And we've asked both parties to be prepared to discuss both of those provisions here today. And as I say, the Mohegan Sun piece will be available tomorrow. So that ends my preliminaries. Does anybody else have any preliminaries that they want to put on the table? Okay. So we'll invite the presenters to speak in the following order. We invite the city that's teed up and ready to go to speak first. We'd invite the City of Revere to go second. Mohegan Sun to go second. I think what we'll do to make this most comprehensible is to give the city an opportunity to speak first, as I said, to address and tailor any arguments to each of the two. We'll have that followed then by the applicant. So you'll have two opportunities. You don't need to take a half hour for each, but you'll have two opportunities and then an immediate response from the applicant. So we'll go city, Mohegan Sun, City of Revere, and then No Easty Casino, and then you'll have another chance to talk about the Wynn process. If No Easty Casino wants to be heard again, that'll be fine, and the Wynn interests will have a chance to talk there as well. And I think we'll do all of those together, and then we'll have a discussion as to how we proceed when we've heard those discussions. So, Councilor Flaherty, Mr. Frangillo, I see that you're here today, and the floor is yours.
Yes. Good afternoon, Commissioner and Mr. Chairman, and through you to the Commission. Attorney Frangillo will be making arguments this afternoon on behalf of the City of Boston.
All right, thank you, Mr. Flaherty. Mr. Frangillo.
Thank you, Commissioner McHugh. Section 15, subsection 13 of the Act specifically provides that there can be more than one host community for a gaming establishment. And as the Commission is well aware, both Boston and Revere were host communities to the initial Sterling-Suffolk proposal to develop a casino at Suffolk Downs. And it's really not surprising, given the location and configuration of Suffolk Downs and the nature of the proposal. The parcel, as you know, has about 161 acres. About 3/4 of Suffolk Downs is located in East Boston. The racetrack straddles the line, and about 2/3 of the racetrack is in East Boston. In the first proposal, the casino buildings were all located in East Boston, and the structures for the racetrack, such as the horse barns, were located in Revere. A vital and critical part of the initial proposal was horse racing. And though the casino structures were not in Revere, Revere nonetheless was a host community. Turning now to the second proposal, the one that's relevant, that's before you, but I mention these points by way of comparison. The second proposal really mirrors the first proposal. Mohegan has stepped in the place of Sterling Suffolk as the applicant, and also has assumed the role of the operator that Caesar's Palace had in the first proposal. But the proposed development, in our view, really simply recycles and rearranges the first casino proposal. And there truly are remarkable similarities between the two. In the second proposal, the locations are simply flipped. The buildings are placed in Revere, and the proposal seeks to move the stables and the horse barns over to the East Boston side, as well as the grandstands. The racetrack, as I noted, was such a key and integral part of the first proposal, and it remains an integral and inseparable part of the proposed gaming establishment. It really is the distinguishing feature of this proposal. It's unquestionably an amenity under Section 2 of the Act. It's a non-gaming structure. It's related to the gaming area. In most of the racetrack, about 2/3 of it, the stables and the grandstands, are going to be in East Boston. The gaming establishment for the Mohegan Sun proposal includes all of Suffolk Downs, most of which is in East Boston. And this point alone renders Boston a host community. Secondly, the business arrangement between Mohegan and Sterling Suffolk provides a compelling independent basis for Boston's host community status. Commissioner McHugh, you mentioned that the ground lease will be posted, or it may actually already be posted. We have a somewhat heavily redacted copy of the ground lease, but it's dated November 27 of 2013 between Mohegan and Sterling Suffolk. And in this ground lease, Sterling Suffolk is leasing property in Revere at Suffolk Downs to Mohegan Sun. But quite importantly, as noted in footnote 1 of the ground lease, the parties acknowledge that Mohegan will manage the racetrack. And that is discussed in more detail on page 9, the section entitled Mohegan Sun to Operate Racetrack. On page 7 of the ground lease, it further indicates that Sterling Suffolk is going to participate in the gaming profits from the gambling operation in Revere. And on January 9 of 2014, Sterling Suffolk notified you in writing that Suffolk Downs is committed to continue horse racing for the 15-year duration of the license if it's granted to Mohegan Sun. So analysis of this ground lease provides you with really conclusive proof that Mohegan and Sterling Suffolk are joint venturers and that the gaming establishment includes all of Suffolk Downs. A couple of final points that also have some bearing on the host community issue is that parking and primary access to the casino. The road access presently, the vast majority of the road access to the casino is going to come through East Boston, Tomasello Drive. And that's located on the gaming establishment, which in our view includes Suffolk Downs in East Boston. Even the host community agreement with Revere severely restricts egress, leaving the casino onto the streets of Revere. So the fact and reality of this is that when people come and go to this particular project, if it's approved, they're going to be traveling, the vast majority of them, through East Boston. And many of them are going to be parking in East Boston at Suffolk Downs, both to attend functions at the track, which is an amenity, and at the casino. And while it is true that Mohegan and Sterling Suffolk are engaged in efforts to try to expand land and relocate Furlong Drive to provide additional access, at the moment that's all speculative. And you're being called upon to make a determination to draw the boundaries of the gaming establishment now. It can't be based on speculative facts. You were within a short period of time, as I understand it, of being prepared to issue a license. And the time now has come. The facts are before you, and these developments with respect to access have not yet taken place. So I think when you step back and you look at what happened at Suffolk Downs, and it all happened very quickly, the initial proponent, applicant likely did not expect that East Boston would vote it down. A substitute proposal was prepared within about a month, and there wasn't a lot of time to radically change issues that existed in the first instance. This is still a project for a casino and a racetrack at Suffolk Downs. The gaming establishment includes about 160 acres, and it really is unquestionable under Section 2 that racetrack is an amenity. It is inextricably linked. It is the leading feature of this proposal. And for all these reasons, we feel that when you go back and you look at the ground lease, you look at the profit sharing, you look at the fact that Mohegan is going to be running the racetrack and the racing operations, it's quite clear. It's a joint venture encompassing all of Suffolk Downs, and we respectfully ask that you vote unanimously that the gaming establishment includes Boston as a host community as to Suffolk Downs and the Mohegan Sun proposal.
All right, Mr. Frangillo, thank you, sir. Questions for Mr. Frangillo? I have a couple. Suppose the first, I recognize you can't undo history, but suppose the first plan had never existed, and suppose this was the first plan. What would your position be then?
I still think that the obligation of the commission is to go back to the statutory definition in Section 2 and to look at what the gaming establishment is and what the amenity would be. And this ground lease ties the properties together. And the ground lease has got the casino operator running the racetrack. It's got the landlord for the 160-plus acres of land sharing in profit for the gaming operation. And I think that these factors, irrespective of the first proposal, put you in a position when you apply, as I know you will, the clear language of Section 2, the result is the same.
Well, let's split those two apart. A profit-sharing arrangement of some kind is not an uncommon feature of a commercial lease, is it?
No.
So profit-sharing by itself doesn't differentiate this from any other commercial lease. It's the horse racing piece that really is the difficult piece. And so let's focus for a second on the concept of an amenity. An amenity, and I think you focused on this in your description, an amenity is something that enhances the value of the sort of dominant estate, if you will, to use jargon. But doesn't it also imply that if there's an amenity, that the thing being enhanced, in this case the casino, has control over the thing that enhances the value? I mean, in a loose sense, you could say that the skyline of the city of Boston was an amenity. And sometimes, in fact, that's used in loose terms. But
I wouldn't agree with that proposition because I think it goes too far.
well, okay.
I think that an amenity, which it has to be a non-gaming structure, could be absolutely owned and controlled by a different entity. But it's the tying back of that amenity to the patrons that are going to be using the casino. And so that is the connecting point in the statute. It has to be in relation to the casino. So if, for example, the casino wants to offer for its patrons, as in the case of WIT, live entertainment with special guests such as singers, as they do in Las Vegas, where they have exclusivity over certain people who will come and sing only for Wynn. But they don't have a facility large enough to fill the venue. This is a considerable amenity for the patrons who come to the casino, who could then go to the TD Garden and go to a concert, whether it's a comedian performing or a well-known band or singer. And the same is true for the Boston Symphony Orchestra. The Boston Symphony Orchestra is housed at Symphony Hall, a structure, a non-gaming structure, as is, of course, the TD Garden. And Wynn is not going to control the Boston Symphony Hall by any stretch of the imagination, but it is offering its patrons a very special opportunity to engage in watching the Boston Symphony Orchestra or the Boston Pops. And we don't, by the way, and I should say, and I know that this is an issue that's been a bit of an issue over time, well before I got involved in this, about the underlying documentation. We don't have these partnership agreements. They haven't been provided to us. We've seen them described in the RFA. And so we're familiar conceptually with what they are and what they mean. And we are also, of course, aware of how Wynn's operation is run in Las Vegas and how the entertainment venue is central to the operation in and of itself. In fact, in the RFA that you have filed, Wynn states that 65% of its revenue is generated by non-gaming amenities. And that's what I'm segueing here, because I'm answering your question, Commissioner McHugh, but they don't have to control the actual physical structure. If they have an agreement, such as a partnership agreement, to use it and to profit and to serve their patrons and to generate the type of profit that they have represented they generate from non-gaming, 65%, then that has to be considered an amenity. And it certainly is not simply cross-marketing within the city of Boston. It's not like somebody earned a few points at the gaming and can use the points at the local supermarket or at a restaurant or something like that, which might be promoting local businesses in the area. This is a very, very different type of partnership arrangement, which I'll address in more detail when we discuss the Wynn host community status issue.
All right, I look forward to that. What do you do, though, with Section 15.3, which requires that the applicant own or acquire within 60 days after a license has been awarded the land where the gaming establishment is proposed to be constructed, provided that ownership shall include a tenancy for a term of years under a lease that extends not less than 60 years beyond the term of the gaming license issued under this chapter?
I'm not sure of your precise question.
How does that clause, i.e., this ties back to my question, Mr. Frangillo, really about control. How does that requirement affect your assessment of the meaning of amenity?
Well, I don't think it changes anything. I think all of these proposals are conditional upon the issuance of the license and then the closing of the deal.
No, I know, but the acquisition of the land where the gaming establishment is proposed to be constructed, doesn't that say, really, that if you've got the gaming establishment, the gaming area and the amenities, it's got to be on land controlled either through fee ownership or through a lease by the applicant, and the applicant has 60 days to do it. So that we're not talking about, and we're not talking about places where you may have a cross-marketing agreement or some kind of an arrangement. We're talking about a physical location that the gaming, that the applicant controls. That bleeds back into the question that I asked you, whether in this case at least, amenity doesn't carry with it the essence of control.
I still don't think that changes the analysis of an amenity.
Okay. I hear you. Let me ask you one more, if I might. I think there's only one more. But no, that does it. I may have some more for you later, but I think what I'll do is give my colleagues a chance to ask questions, and then we'll hear from, who did I say? Somebody. We'll hear from the next person.
I'd like to make clear that before the city embarked on joining the process, we didn't file, as you know, a brief and
Yes, sir.
affidavits and materials. We weren't really sure what we were going to do. We were looking at all of our options. And host community issues are, I think, complex. The statute may be written in a fairly simple form, but the actual underlying issues can be intensely factual. And one of the problems that we had, and I want to speak candidly and frankly with you about this because I would like this to be a discussion, was that we were concerned that we didn't have access to all the information and details. And as those of you that have been involved in any type of litigation or a formal adjudicatory process permitting discovery, generally you can find out what went on. You can get the documents, you can get the partnership agreements, you can see the emails, you can find out all the details you need to be able to fully vet an issue. And I'd like to recognize the fact that we have not engaged in that process. We wish that we had the opportunity to do that. We have prepared, in fact, extensive affidavits. We have looked at many, many issues such as permitting, zoning, and they can't all be discussed, obviously, within a 30-minute time frame. But we did look at this quite seriously. We had some concern, obviously, about the process. We had some issues concerning jurisdiction because we know there are some gaps in the statute, and Massachusetts does have a provision for determining the status of parties under a statute, a very express statutory right to seek a declaratory judgment to have your status determined, as a former judge is well aware, under General Law, Chapter 231A, Section 2. So we've thought about a lot of these issues long and hard, along with the team of Nutter, McLennan, and Fish, Bill Kennedy and Mary Marshall, who are here, as well as my colleagues, Ariel Raphael and Caroline Simons. And we're prepared to answer and discuss every aspect of these issues that you have. And it may take more than 30 minutes. You may want to confine it to 30 minutes. You may think that that's plenty. But we have looked at this long and hard. And there are legal authorities. And again, if you don't want to discuss all of that, I understand it, because you gave us the opportunity to submit a brief and we didn't. We weren't sure what we were going to do.
Right.
And that's why we don't have all these materials. And in fairness to the applicants, they haven't read all of our arguments on these points, and they've tried to do the best they can based on statements that we previously made.
All right, Mr. Fangello, thank you for your candor in that regard, sir. Let's move on to the next step and see where we go. And the next step would be to hear from the representatives of Mohegan Sun, and of course we'll come back to you for the presentation with respect to Wynn. All right, good afternoon, gentlemen. Mr. Conroy, I take it you're going to take the lead, but would you, for the
Yes, I
record,
will.
Introduce the...
I will
Just to your
introduce our
right.
team here. Thank you, Commissioner. I'm Kevin Conroy from the firm of Foley Hoag, representing Mohegan Sun. With me is Charlie Baker from the firm of DLA Piper, representing Sterling Suffolk. We decided to save the commission some time today, and the City of Revere is going to present with us. And that's Brian Falk from the law firm of Merrick O'Connell, representing the City of Revere. Next to him is David Rome, the general counsel at Mohegan Sun, and then Bruce Barnett from the law firm of DLA Piper. Again, we're going to try to keep this brief, mix the time that Mohegan Sun and the City of Revere had. First, I want to thank Catherine Blue and Todd Grossman. Commissioner, last week you gave us a challenge. You mentioned that you would like to see and like to have a discussion about the racetrack provision in the binding agreement. I think you also indicated to us that you would like the public to have the ability to view that document. Catherine, Todd, and the Mohegan Sun team had a fair number of negotiations this past week. We're very, very happy that we came to an agreement and that document is going to be released to the public. And we're pleased that document is going to be released to the public as soon as possible. And we know that was a goal of yours and the commission's. And thank you, Catherine and Todd, for your efforts in that. Charlie Baker is going to talk in a little bit about the racetrack provision that is in the binding agreement. I know that's something that you talked specifically, you wanted to hear some about today, Commissioner. I'm going to just talk a little bit about Mohegan Sun. We talked a little bit earlier about the definition of a gaming establishment. I'm not going to read that again. But consistent with that, the entire Mohegan Sun facility is in Revere. Our RFA2 application clearly describes it. We have a 99-year lease with Sterling Suffolk, and that document is going to be released tomorrow. Mohegan Sun is the tenant. Sterling Suffolk is the landlord. The plan of that lease premises clearly states that our premises is in Revere. We've leased 40 acres in Revere. Now, Sterling Suffolk certainly owns more land. Mr. Frangillo talked about that. It owns land adjoining the Revere portion of the property that we have leased, and that land is in Boston. Comes to no surprise to anybody, there's a racetrack on that provision of land in Boston. And I think everybody else also knows that our landlord, Mohegan Sun's landlord, Sterling Suffolk, they at one time were an applicant for a Region A casino. But But the task for the commission today is to figure out what Mohegan Sun's gaming premises is. And what Sterling Suffolk's gaming premises does not reflect on that. And what our project is gaming areas, 2 hotels, food and beverage, retail, entertainment venues, meeting and conference space, a spa, structured parking. All of those structures are in Revere, consistent with our binding term sheet, our lease. Our entrance to our casino. At the intersection of Furlong and Tomasello Drive, there will be a sign there. That sign and that roadway lead up to our casino. Our entrance is in Revere. The primary access road to our facility from a public way is along Furlong Drive, coming off Route 1A. That is in Revere. We also have a pedestrian entrance that comes because of our public transportation access. That is at the intersection of Winthrop Ave and Washburn Ave, right next to the Beachmont T Station. That is in Revere. And finally, it's not clear whether water and sewer connections would deal with the definition of what is a host community or a gaming establishment, but our water and sewer connections are all in Revere. Now, let me talk a little bit about the racetrack and this question about whether the racetrack is an amenity. And I think the best way to look at this is to actually do what Mr. Frangillo did, which is let's look at what Sterling Suffolk's prior proposal did, and let's look at what the Mohegan Sun proposal did. Sterling Suffolk's proposal, the racetrack and the casino were the same. The casino was in the racetrack. The casino and the racetrack were intertwined. They were together. They were the same structure. They were part of each other. Mohegan Sun's proposal is much, much different. There's a clear separation between the racetrack and the casino. First, the casino and the racetrack are on legally separate properties. We are leasing a property in Revere, and Mohegan Sun will have control over that property. The racetrack property is legally separate from the Mohegan Sun's property, and that gets to your point, Commissioner, about 15.3. Second, there is a significant distance between the entrance of our casino and the entrance of the racetrack. It is about a half mile. A casino patron will have to walk out the door, walk a half mile to get to the racetrack. And to put that a little bit in perspective, Commissioners, your office is on State Street. I think it's 84 State Street. If you walk out your door and you walk all the way to TD Bank North Garden, that's about a half mile. It's a little bit longer, but about a half mile. That is the distance one of our patrons will need to walk in order to get to the racetrack. Finally, you've got 17,000 pages of documents in our RFA2 application. Many of those pages, some of those pages, talk about how we are going to market this casino. We talk about how we're going to market our boutique hotel, how we're going to market our main hotel. We talk about how we're going to market our casino. We talk about how we're going to market our spa and how this is all going to work together. We talk about how we're going to work with Revere Beach. Nowhere in those documents do we talk about a marketing agreement with the racetrack. We are not planning to include the racetrack in our promotions. We are not planning to advertise the racetrack in our promotions. And the 17,000 of pages that we've given you in that RFA2 application make that clear. So I know, Commissioner, you want to talk a little bit about the racetrack provision that is in our binding agreement. I'm going to turn it over to Charlie Baker from Sterling Suffolk to talk about that.
Thank you, Kevin.
Before you do that, Mr. Conroy, no, that's fine. That's fine. Go ahead.
Sure. Thank you. Thank you, Mr. Chairman. So we had a conversation with your general counsel to prepare for this meeting, and she raised the fact that at least a commissioner had a question about the provision in the binding agreement called the racetrack provision. And what we told her was, look, we clearly wrote this agreement knowing what the underlying law and structure was, and knowing that we would not want to put anything in this agreement that made the racetrack part of the gaming establishment. That the Mohegan Gaming Establishment is solely the leasehold premises, which is solely in Revere. The provision in question gave us the right, gave Sterling Suffolk the right to ask Mohegan at some future date to manage the racetrack, not to own it, it would separately be owned by Sterling Suffolk. That right to manage would have to be approved by you, the Gaming Commission, so it would have to be.
Well, to ask isn't quite right. To put management.
Well,
was a put.
we have but it's an option, and
That's why it's a put. It's an option
It's
on
an-
your
it's
part.
an
It's
option.
not a two-way option.
that's correct. We obviously submitted this document to you on December 2nd. We never thought that anyone would view this as somehow combining the two facilities. When we heard Catherine's point that there had been a question raised about this, we simply told her it was not a material part of the document, and by mutual consent, the parties have stricken it. So we don't believe it makes the racetrack part of the gaming establishment. It was not our intent to do so. There's a big difference between owning and controlling an operation and being a manager. Most office buildings and hotels in Boston are owned by one person and managed by another. Doesn't change who the owner is. It certainly doesn't change who the applicant is for the Revere-only Mohegan Casino. But in the interest of clearing this issue up, the provision has been stricken from the agreement. We later filed a letter, Sterling filed a letter with Catherine clarifying this matter and clarifying the relationship of the provision and the racetrack to the application, Mohegan's application.
Well, what do you say to Mr. Frangello's contention that if, well, maybe it's my gloss on Mr. Frangello's contention, that ownership and that control of an amenity is an essential ingredient of amenity status?
I believe your point about 15.3 is correct, which is...
No, I'm not talking about 15.3 now. I'm talking about the concept of amenity, which goes back to what is a gaming establishment. Gaming establishment is the gaming area and amenities that the...
I believe that the amenity has to be part of whatever real property the gaming applicant controls. I don't see any other way to read that.
I see.
There are many amenities.
15.3 is a defining part of gaming establishment.
I don't see, and we've obviously thought about this a lot. We've been dealing with this, on behalf of different applicants. I just don't see any reading where someone can have an amenity that's part of a gaming establishment if the amenity's not in the gaming establishment, and the applicant has to own and control the gaming establishment. So I just don't see another reading. And there are plenty of amenities to the Mohegan Casino that they will never control. There's Revere Beach, where they're looking at doing a partnership with DCR and having concerts.
Well, I know, but that's amenity in a loose sense. That is amenity in a sort of a advertising brochure sense. We're talking about amenity in the context of the statute. Amenity,
I don't...
which triggers potentially at least a registration requirement for everybody who works there.
Sure. The racetrack is and always will be separately owned by Sterling Suffolk Racecourse LLC, and it is not part of any real property which Mohegan has any right to control or take actions upon. There was an option that Sterling could have used to ask to require Mohegan to manage the facility. It was clear to us that that was creating confusion. It's been gone. It's removed. It's removed from the agreement.
What about footnote 1?
Footnote 1 just makes clear that they don't have any obligation to...
Who's the they?
They, Mohegan, has no obligation to pay racetrack losses. Those are Sterling's obligation, unless that first provision, unless that option were exercised. The option no longer can be exercised.
Time out.
Okay.
Which option?
Sterling's option to ask Mohegan.
To put to Mohegan. Let's
I
be clear.
I don't call
People will
it.
be able to read it tomorrow, but
I
let's
don't.
be clear.
Well, no, I don't think it's a put, sir. I mean, in all due respect, a put is they get to own it. They don't.
No, you put the operation, you have the right to put the operation to Mohegan Sun. You have the right to require them to operate the track. Now, I recognize your position that it's gone.
Okay.
It's no force and effect. You've withdrawn it. But properly characterized, it's a put of operating responsibility. It's in that sense that I'm using put, not in a stock sense, because it's a one-way option.
Well, I guess I'm not going to argue about the use of
All
the
right.
word put,
All
but
right.
what I would say is that with that option put gone, all footnote 1 now says is that any losses at the racetrack are Sterling's. And that is in fact the case.
All right. Questions from
Yeah,
my
Mr. Conroy,
colleagues?
remind us, what is the amount of acres that Mohegan is leasing?
We are leasing 40 acres.
40 acres. Are all those 40 acres all of the property in Revere?
Yes.
Is there any more property for Suffolk Downs that also sits in Revere that is not being leased?
The answer is yes. There's a portion of the racetrack that is in Revere.
So on the site plan, where the racetrack curves
Right.
around, that is not being leased by?
It is not being leased by,
Mohegan?
it is not being leased by Mohegan Sun. Any portion of the property, whether it's in Boston or Revere, that's necessary to operate the racetrack is remaining with Sterling Suffolk.
Thank you.
Other questions from commissioners?
Just a quick question, Attorney Conroy. You talked in the RFA2 application, there really is made no reference to the marketing of the racetrack is something to do, I guess, when you visit Mohegan Sun, Massachusetts. I'm trying to understand, when you came before us to make a 90-minute opening presentation, there certainly was substantial material in that presentation. We heard from racetrack employees, we saw pictures of horses. Help me understand the relationship between where the RFA2 application is and the content of that presentation.
Thank you for that question, Commissioner. It's a really good one. We think when you go to the definition of amenity, the question is whether the gaming area is related to the amenity. And when I talk about marketing, the fact that we're not marketing the racetrack to me is an indication that this isn't our gaming area, is not related to the racetrack. Your question I view as separate, which is there is no doubt that, and we've made clear to you, and Sterling Suffolk has made clear to you, that if Mohegan Sun gets a license, Sterling Suffolk has said that they are going, those profits that come from the lease that we have with them, those profits are going to help maintain that racetrack, and they are going to keep that racetrack open for 15 years. And so that they are going to use the profits that they get from this lease. We will be making payments to them consistent with the commercial lease that we have with them, and that those payments are going to help them maintain this racetrack, and they are going to keep that racetrack open for 15 years. And so that doesn't create an amenity. Our landlord is going to use the profits they get from the lease that we have in order to keep this racetrack open, in order to keep those jobs going.
Thank you.
Other questions? All right, let's hear then from the city. The city of Revere. We have many cities.
Thank you, Commissioners. As noted by Mohegan Sun's representatives, Revere is the only municipality in the Commonwealth that meets the statutory definition of host community for Mohegan Sun's proposed gaming establishment. But Revere is not a host in name only. The city's host community agreement intends that Revere will be the sole host for the project and will provide all essential municipal services to the project. The primary and secondary driveways to the project are located off of public ways, located entirely within the municipal boundaries of Revere. Public transportation stations serving the project, including the Beachmont Blue Line Station and Winthrop Avenue stops for the 119 bus, are located entirely within Revere. As requested by the applicant, all water and sewer service to the project will be provided by Revere without relying on neighboring municipalities. Finally, police and emergency services will be provided by the Revere Police Department and Fire Department, with no expected increase in mutual aid calls. For these reasons, and for the reasons stated by Mohegan Sun's representatives, City of Revere respectfully requests that the Commission confirm Revere's status as the sole host community for Mohegan Sun's proposed gaming establishment. Before I close, I want to make some comments about process from Revere's perspective. I'm glad to see that Mohegan Sun has publicly released its binding agreement. It speaks to their ongoing efforts towards full transparency. As Commissioner McHugh mentioned, the comparable documents for the wind project remain undisclosed. Frankly, I don't understand how you can reach a decision on Boston's status without resolving the
Well,
wind land.
now, you're here to talk about Mohegan Sun, and I'd request that you focus on Mohegan Sun.
I'd like to speak to the,
Well, in competitive argument, I think, is out of order at this stage. So if you
but it
have
speaks to
something-
the process, Commissioner McHugh,
Yeah, I
in terms of
understand.
where Mohegan Sun is and where wind
Yes,
is.
well, I understand that, but we're not talking about a competitive fight here. There'll be other platforms for that. We're talking about the issues as to whether or not Mohegan Sun, whether or not Revere is the sole host community for Mohegan Sun, and not about what other people have done or haven't done to comply with our procedural requirements.
But we're subject to the same
Now,
process.
I don't want to get more strong than that, sir,
Thank you,
but you're
Commissioner.
out of order.
Thank you.
Thank you. All right, thank you very much. All right, the representatives of No Eastie Casino, would you like to be heard today? We have in mind, of course, your remarks from the last occasion, but you're here, and we look forward to hearing from you.
Good afternoon, Commissioners.
Good afternoon.
Thank you for having us here today. As you described, we did give some pretty robust testimony last week, and so we'd just like to take the opportunity to hit a few high points, not the least of which to thank the City of Boston for their testimony and their continued stance that you cannot extract East Boston from the impacts of a Suffolk Downs casino. You know, a quick little Google on my smartphone yielded that the definition for a host is a person, place, or company that provides services or resources, etc. Now, I have expressed a great deal of frustration at an inability to always being able to wrap my hands around cut and dry responses and definitions for elements of the process. I think this is at one juncture where we got it right the first time, when you talked about the initial application process and the initial proposal for a Suffolk Downs casino. We more than cordially included Revere in the process because they would be definitely majorly impacted. The same is true of East Boston. If you look at some of these other developments in Western Massachusetts and other regions, you can argue that the sites where the traffic is coming and going and where the burden of development and access and the like isn't necessarily felt as much as it would be in a Revere destination casino. There's no way that you can have 25,000 to 35,000 vehicles with all of their passengers on a daily basis heading to a Suffolk Downs casino without impacting East Boston, Chelsea, Winthrop, and all of the surrounding communities. I mean, if that were the case, I'm sure that the developers would have no problem seeing that they described that every element of this development proposal resides in Revere. If we went ahead and put a brick wall across 1A between East Boston and Revere, and if we put a brick wall in the middle of my street, Bennington Street, which is right behind Suffolk Downs. If that were the case, I'll go ahead and I'll get the bricks tomorrow if that would save me from the impacts. And then, the other piece that I just want to hit on is, they made a valiant effort of saying how there was no way that it's been marketed, that Suffolk Downs will be part of this. However, it was the very, very crux of their campaign. It was the very, very source of the heartstrings that they were pulling on. They were pushing for the nostalgia, for the jobs, and you know, even the heart of the disingenuous attempt by Chip Tuttle with his letter describing that they intend to stay in business for at least 15 years. As far as I'm concerned, that's equivalent to a love letter. I can write you a love letter saying, I will love you forever, or at least 15 years, but you can't hold me to that. The way we could have held Suffolk Downs
You
to
weren't
that.
planning to do that, right?
I'm sorry? I think you'll be sick of me by the time this is over. But, you know, the only way that Suffolk Downs could have been held to any such declaration was via the mechanisms that already exist within this legislation, within host community agreements, and within, you know, ballots and the like. They extracted themselves very deliberately from that process. They handed over the application to Mohegan Sun to divest themselves of that responsibility. And to say that anything else is true is just disingenuous. So all along, these folks have been fighting to have it both ways. You know, either they're connected to Suffolk Downs or they're not. And if they're not connected to Suffolk Downs, then the campaign was a sham, the election was a sham, and that's a whole nother can of worms that we'll be getting into. And I'm glad to fight that fight too. But I'll hand it over to Matt Cameron now. Thank you.
Thank you.
Good afternoon, Commissioners. Very briefly, commend the City of Boston for the outstanding presentation, and I certainly don't want to reiterate the points that have been made. They're very well done. And we already got into the issue of the track at the last hearing, but I do want to respond to a few things that have been presented today by Mohegan Sun. You know, I spend most of my day job fighting the American immigration system, and that's an uphill battle if there ever was one. I understand a tough argument when I hear one. I don't understand a lot of what we heard today. I'm going to be pointing out page 12 of Mohegan Sun's brief covers everything that has just been discussed by Mohegan Sun regarding the track for the last, I think, maybe 15 minutes of their presentation, when they're trying as hard as they possibly can, and I appreciate the efforts, to disentangle themselves from this piece of property.
Subparagraph D, section D.
That's
is that
right,
what you're
yeah,
referring
page
to?
12. This is, I would just point out, this paragraph is the entirety of their argument on paper. And it refers to the racetrack. In fact, the word racetrack is not used anywhere in here. It refers to the racetrack as Sterling Suffolk's property in East Boston. It describes how this property necessarily abuts the remainder of Sterling Suffolk's land, the remainder of Sterling Suffolk's land. You would never know from this description what was on that land. But we know full well what was on that land because that's been the central issue in this entire casino campaign for the last 4 years, since the very beginning, since before this legislation was written with the intent of putting a casino at Suffolk Downs. It has been with this track in mind. And we don't have a problem with that, but I think that it's best that the parties acknowledge that that is what is central to this entire discussion. And for them to come now and to say that they have, I mean, they've actually openly told this commission, just a few minutes ago, they told the commission that they went out of their way to try to write a lease agreement which would disentangle them from the Mohegan Sun property and which would skirt this law, which would actually get around the requirements that they not have an amenity on their property in East Boston, which I'm sorry to say again, no, actually I'm not sorry to say again, which East Boston actually, and the City of Boston, has actually resoundingly already told this commission it doesn't want a casino. And the entire purpose of this lease agreement is to make sure that we get one. By the way, this lease agreement, I have not yet seen, the public has not yet seen, we'll be seeing it tomorrow, and I certainly appreciate, Commissioner McHugh, your efforts in making sure it gets out there, and I appreciate that now the applicants are working with us to get it out. But we've just had, I will point out, a discussion on the record about a document that only the parties have seen, and in fact the City of Boston is telling us they've only seen a redacted version of. It's an absolutely essential document, central to this question, and we haven't seen it. So I'm surprised to hear some of these provisions. I'm absolutely shocked to hear that it says on the first page of the lease agreement that Mohegan Sun is going to be running the track, because that's certainly not what we've been told for the last 6 months. We've been told that Mohegan Sun will be a tenant and that Suffolk Downs will be a landlord. I would not allow my landlord to run my business. I'm doing a bad enough job of it myself. I would never allow my landlord to step in and run my business. And again, I'll reserve until I actually see the lease. And I appreciate that it's coming out tomorrow, but certainly it would have been helpful for the purpose of this hearing to know what was in it before, because it is absolutely central, despite Mohegan Sun's attempts to distance themselves from the piece of property that has been the central crux of this application. It is essential to understanding whether or not we are to be hosting a casino. And of course, our default argument, no matter what, is that we will be hosting a casino. But I think that the applicants rightly recognize that this is their weakest argument. It's the thing they spent the least time on in the brief. As an appellate judge, certainly, Commissioner McHugh, you recognize that often your last argument is your worst. Not always, but often. And it's the thing that rightfully has been the thing we're talking about the most today, because it is the single most important argument in this particular application as to whether or not the City of Boston will be hosting a casino. Elsewise, I just want to point out that this is a regional project. 25% of the predicted patrons will be coming directly from Suffolk County. 25% from Chelsea, from Revere, from the City of Boston. 51% will be coming from Norfolk County, Essex County, and Middlesex County, and only 3%, by what I understand, I'm not very good at numbers, but what I see in the RFA 2, 3% will be coming from outside New England. This is a regional project. It deserves a regional vote. It deserves an understanding that this is different in kind, as we have said in our brief, different in kind from any of the other proposals, in that it includes any number of municipalities that are around, the most important and the largest, and the one that will be most directly impacted being the City of Boston. And again, we really appreciate the city's efforts on our behalf to defend our vote and to make sure that we get the host community status that we rightfully deserve. Otherwise, I think we'll reserve the remainder of our argument as to the less tangible benefits after we've heard from the Wynn applicants.
All right, thank you. I want to make it clear, of course, that the commission has seen these documents. I had hoped, as we said, that they'd be up and posted so everybody can see them, but I believe they should be, and they will be. But the commission surely has seen them, so we're not moving in the dark.
Well,
So
I certainly appreciate that, Commissioner, but I do want to point out we did make a public records request for them a couple of months ago, last month.
And that's right. And we have taken the position that those were trade secrets. We've looked at it again. We've revised that determination, and when we revise the determination, they have 14 days to object. So we're trying to do this by the rules that are fair to everyone.
And we thank you for that.
Right.
Much appreciated. Okay.
So, all
Thank
right.
you.
Thank you very much. Now, I think that we will move to the Wynn presentation and then go through this scenario again, unless anybody wants to take a brief pause.
5-minute break, maybe?
5-minute break? All right, let's take a 5-minute break. This one will be a real 5-minute break, and we'll be back in 5 minutes. All right, I'd like to reconvene the proceedings, if we might, please. All right, Mr. Frangillo, Mr. O'Flaherty, let's pick up where you left off, sir. The floor is yours, this time with respect to Wynn.
Thank you. The host community issue with Wynn is a significantly different one than the issue with Mohegan, and actually starts at a different place. We're tasked here with determining what the gaming establishment is, but with Wynn, the first question is there, in fact, even a valid gaming establishment, as opposed to determining simply its boundaries or parameters? And what I mean by that, it has to do with an issue that you raised on Friday, and unfortunately, an issue that has surfaced in this case, and it's got to do with the validity of the land deal with FBT Everett, and whether, in fact, there is even a valid gaming establishment for the Wynn applicant. And I'm sure that when you undertook your responsibilities a couple of years ago, with the exception of perhaps Commissioner Cameron, none of you were expecting that you would run into this type of situation that arose. And what I'm speaking about specifically is the FBT Everett ownership of the land and the issues that became the subject of your hearing last December. But unfortunately, those issues do impact whether or not there is a valid gaming establishment, and I'll address them briefly. If there is no enforceable or valid option agreement between FBT Everett and Wynn. There is no gaming establishment. And there are issues here that we believe you need to consider in ruling on this. In the report that was submitted last week by Director Wells, she expressed her grave concern about the cast of characters who own FBT Everett. In Section 14A of the Act requires the Commission to render a suitability determination for all parties, persons or entities, that have an ownership interest in the gaming establishment. FBT Everett owns the gaming establishment as defined by Wynn. They are collecting about $100,000 a month, so we've been told. And that has been going on for probably about a year and a half, which would be about $1.5 million that has been paid. With the revision or the 9th amendment to the option agreement, which we have not seen, we've only read about it, that document indicates that there has been, as a result of the proceeding in December, an adjustment in the purchase price from $70 million down to $35 million, with a specific allocation of $10 million of that for environmental purposes. But the report that was issued by the Bureau contained a vast amount of compelling evidence that the owners of FBT Everett attempted to perpetrate a fraud upon this commission by not disclosing certain ownership interests of people, or at least one, who was a convicted felon. And we know that from the prison tape recordings, they used an LLC, according to Mr. Lightbody in his discussions with Mr. Buffalino, to hide his ownership interest. None of these individuals, Mr. Gattineri, Lonis, or D'Annunzio, came forward to discuss this or address it with you. And then the investigation commenced. And during the investigation, a number of individuals exercised their Fifth Amendment right. There was a discovery of the backdating of an operating agreement and backdating of other transfers of interests. There was widely conflicting testimony about what the facts were. And I think it's fair to say, as summarized in the Bureau report, there was an attempt to obstruct an investigation.
Mr. Frangillo, these are all facts that we know.
Yes.
This commission was probably the first one to learn about all those facts.
Correct.
Where are we going with this?
What these facts mean is whether or not you can render a suitability determination of FBT Everett under Section 14A, because they have a financial interest in this land. And the statute makes it mandatory. They have been getting paid $100,000 a month. They will get paid a substantial amount of money. They will make between a 300% to 400% profit on their $8 million investment if this license is awarded and Wynn gets the casino and the sale goes through. And what I'm saying, Commissioner, is that the evidence that you have before you in the referral that you made to the United States Attorney's Office, to the Attorney General of Massachusetts, and to the Suffolk County DA's office is indicative of the fact that you cannot find the FBT Everett owners to be suitable. And they are required to be suitable for the application to go forward. And there is a burden placed under Section 12 of the statute on the applicant to demonstrate the integrity and the honesty of other parties required to be determined suitable. And I also note that you have broad discretion under Section 4, subsection 11, to require the suitability of all business associates of the applicant. And I think that Chairman Crosby made the point well in his opening comments that the real purpose of the function here, of the regulatory body, is to maintain the public confidence in the process and the integrity of the process. And the evidence that is in the Bureau report is quite clear that there has been underlying criminal ownership, and that the people that are involved, that are still in the chain of ownership, that are going to profit handsomely, that tried to defraud this commission and obstruct its investigation, cannot possibly be deemed to be suitable under the law. And what that does to the option agreement is, in Massachusetts, agreements that violate public policy or which are illegal are void and unenforceable. And in this particular matter, because the gaming statute has specific provisions in it to rid this process of people involved in criminal behavior, but not just criminal behavior, a pattern of conduct that would be deemed to be unlawful, whether prosecuted or not. And I submit that under Section 38 of this statute, under the Gaming Act, when you review it, and I'm sure you already have, you may have had criminal matters that were perpetrated in these proceedings by people who are going to handsomely profit. So there is a question about the legal validity of this Ninth Amended Agreement. And I understand that the Commission, when faced with this issue, which nobody expected would happen, nobody was expecting that these prison tapes would be revealed, attempted to cure the situation in the best way possible. And also with the understanding that competition amongst applicants is important, because with competition, the best proposal will be forced to come forward. And so with the difficult situation that you were faced with, and with an attempt to try to eliminate the so-called taint, what ends up happening, unfortunately, is that people who attempted to defraud you and who obstructed your investigation get to make a 300 to 400% profit on an investment if a casino is awarded in Everett. And you might say, well, why does all this matter to Boston? And the fact of the matter is this: when any applicant comes forward and files an application, and the city is an adjoining community, whether it's a surrounding community or a host community, because the way both of these proposals, they were literally casting shadows into the streets of Boston. They were right on the border. The city of Boston had to spend hundreds of thousands of dollars with consultants and legal advice to analyze the impacts of these proposals, so that either a host community agreement or a surrounding community agreement could be entered into, and that the city would have a basis to negotiate. And so the city has statutory standing. They are deemed to be an aggrieved party. There's even a set-aside in the statute authorizing, I believe it's $40,000 or $50,000 to be given to these surrounding communities or host communities to determine the impacts of these proposed projects. And in this case, for example, for this particular applicant, there is a $100 million project to alleviate traffic in Charlestown and straighten out a long-term problem in Sullivan Square. That is directly impacted by this. And to properly analyze what those impacts were, the city had to expend significant resources. And the problem is that a group of people attempted to hide a disqualifying factor from you so that they could make a handsome profit. And another measure you tried to impose to add some integrity to this was the certification issue. The problem with that, unfortunately, was that the people that you were asking to certify under oath that they and only they were the owners were people that you had already determined, because of the evidence in the Bureau report, weren't trustworthy. And now we have the situation that was addressed on Friday afternoon, that the third certification, which really was a fairly minimal requirement imposed. You tell us you're the owners and you're the only owners and nobody else is going to profit from this. It hasn't been forthcoming. So the question about whether you even have a gaming establishment, in our view, we don't believe FBT Everett can be deemed suitable under the statute. If they're not deemed suitable, that ends and disqualifies the applicant. But in addition to that, we believe that the contract between the applicant and FBT Everett violates public policy, including the policy of the Gaming Act. So we begin from a different point with Wynn, and the question was asked, I believe, by Commissioner Cameron about whether the applicant had any involvement in this and what proof was there regarding that. And the answer was that the applicant did not, as far as the Bureau was concerned. And while that may be an appropriate issue for federal law enforcement that are actively conducting a grand jury investigation about this, there is a corollary question that was not asked that should have been asked. And that was, could this have been avoided and should it have been avoided? And the answer is a resounding yes. The applicant has an affirmative obligation under this statute to conduct an investigation of its associates, affiliates, business associates, to determine their integrity and their suitability as required by the law. There is a burden of proof placed on the applicant to do that. This is a casino. Due diligence needs to be done on these types of people with whom there has been no prior relationship whatsoever. The applicant was proposing a $1.5 billion project on a $75 million piece of land. And when questioned by your outside counsel, my former colleague and very capable lawyer, Mr. Mackey, when he questioned about what the diligence was done, it was to review the 12 pages of public filings with the Secretary of State on the LLC, which, as we all know, tell you nothing about the ownership. They only tell you who the managers are. And in fact, Charlie Lightbody in his tape recording made it very clear why they used the LLC, to hide ownership. So you need to peel back a layer of the onion. And in a deal of this magnitude, and I've been involved in many, the type of due diligence that is required, because after all, going forward, this is supposed to net the applicant billions of dollars, is to use the machinery that you have, all the former law enforcement people and Navy SEALs and people that were former high-level government officials, to conduct extensive due diligence of who you're dealing with. And when the general counsel of Wynn was asked what was done, it was to check what was on file with the Secretary of State. And this whole thing could have been obviated with a simple request for the operating agreement of the LLC. The operating agreement, and legitimate LLCs all have operating agreements. They tell you who the owners are, they tell you what the capital contributions are, and they reveal information about the company. All that needed to be done was a simple request: let us see your operating agreement. Now, if there was no operating agreement, immediately a big red flag would have gone up as to the legitimacy of the entity. And it was known to the applicant from the outset, because the Boston Business Journal ran an article before the option agreement was even signed, that one of the founders of FBT Everett was a convicted felon. And the diligence that was done on that was to ask Mr. D'Annunzio, what happened to his interest? Oh, he sold it, he's out. Not who did he sell it to, or let me see where that interest went. And based on the Bureau report, we now know part of it went to Charlie Lightbody. And so, with minimal, even basic due diligence done in November or December, before this even got down the road, it could have been determined who the owners were of FBT Everett. It's required under the statute that that type of investigation be done, and instead, the Wynn representative, the general counsel, came before you and said, we did extensive due diligence, we did all this and we did all that, and it basically boiled down to looking at 12 pieces of paper on file with the Secretary of State that anybody in here could click onto a website and review, and they say nothing about ownership. You wouldn't even buy a $200,000 condominium without knowing who the owners were, or the owner. But this project went forward, and Boston spent a lot of money and continues to spend a lot of money. And there's a question right now about the legitimacy of that contract. And so we start our argument by saying that we would like you to look and investigate this. And we know you've investigated the underlying facts. We quite frankly believe that based on the evidence before you and the fact that you've referred the matter for criminal investigation and possible prosecution, that you can't possibly determine that the FBT Everett owners are suitable. And they shouldn't be entitled to earn a penny of profit on this. Not one red cent for what they've done.
All right.
I now want to turn to assuming that there is a valid agreement. I'll turn to the issues about host community, directly about host community. When the RFA 1 was filed back in January of 2013, there was only one way in and one way out to the former Monsanto chemical site. It was Horizon Way. You had to use Horizon Way, and about 60% of it is in Boston. Today, as we sit here and are deliberating on what is the gaming establishment, there is still only one way in and one way out, and that is using Horizon Way. Back at the hearing on September 4, the city of Boston came forward and the law firm of Goodwin Proctor made a presentation and showed you some promotional materials that Wynn had used at various meetings leading up to the host community agreement and the vote in Everett. And those promotional materials, which granted were early in the process, unquestionably showed the inclusion of land in Boston. You have them as part of the record before you. They were color photographs from that September 4 meeting. After that, Everett entered into a host community agreement in which it was dated April 19, 2013. The host community agreement between Wynn and Everett has a description of the site. It actually has an attachment. It's a one-page attachment. It's Exhibit A to the host community agreement. And it clearly shows Horizon Way on the property. The host community agreement also discussed a proposed new driveway proximate to Horizon Way without much by way of specifics. The host community agreement never said that Horizon Way was going to be abandoned. And it never said in there, I'm sure when you review it you will see, that the proposed driveway requires the purchase of any additional land or easements. It also doesn't say that the new driveway is conditional. It says it's going to happen. It still hasn't happened. The land that would be needed for the driveway as we now know it to be, we don't know if that's what was contemplated back in April of 2013, but the land as we now know it to be still hasn't been acquired. Yet the people of Everett were led to believe that it's going to happen. This is the new driveway, not the proposed one that's a conditional one. So the vote went forward on June 22nd, and the ballot question that the people of Everett were asked to answer said the following: shall the city of Everett permit the operation of a gaming establishment licensed by the Massachusetts Gaming Commission to be located at property located on Horizon Way, off Lower Broadway in Everett, formerly known as the Monsanto Chemical Site? That's the question they were asked. It includes Horizon Way, and it describes the former Monsanto Chemical Site. We all know in this room that the former Monsanto Chemical Site includes 5 to 8 acres of land in the city of Boston. There's no delineation here, oh, well, a parcel C has been cut off and given to another wind entity or anything like that. It's the former Monsanto Chemical Site. So anybody who picks this up and reads it will believe that Horizon Way is part of the gaming establishment, and the former Monsanto property, which includes land in Boston, and a lot of it, is part of the gaming establishment. And that's what the people of Everett voted on. But then things changed after that. That was June 22nd. And the city first came before you on this issue on September 4th. But Wynn, at this point, began to become the proponent of an altered design, a design that would come through the side boundary, solely through Everett, onto properties that included land with the MBTA. It was Wynn's objective at that point, and they stated it very clearly at this hearing, that they were going to try to carve out every piece of Boston that they possibly could so that this site will be located exclusively in Everett. That's not what the voters voted on. Nowhere does it say that on the ballot. But the proposed access and all the fancy drawings that you've seen about how this is going to happen, and you've even heard now that it may be because things haven't fallen the way they were anticipated to, maybe it's the third certification not being signed, that now there's this proposal to take it all by eminent domain. The fact of the matter is, it hasn't happened yet. There is still only one way in and one way out, and that is a road, a private road, that is in part in Boston. And on February 11, 2014, Mass DOT even submitted a letter commenting on the draft environmental impact report, expressing reservations about this proposal. So the whole question of the gaming establishment and host community status, it unquestionably has to be based on facts, not speculation, not conjecture, not hypothetical plans that have not materialized.
But Mr. Frangella, you've been going on and I've been listening carefully to what you've said. Under the statute, the applicant is required to acquire the land that it proposes to put the gaming establishment on within 60 days after the award of the license. Doesn't have to have it in hand when it files the license. Doesn't have to have it in hand when it begins to appear before the commission. Doesn't have to have it in hand today. It does have to have it in hand 60 days after the license is awarded. And the commission is perfectly capable of imposing a condition on the license that it conform to the application that's been specified in the filing that the applicant makes. So while all of this is interesting, and all of it is, I wish we'd had a little bit more advanced notice of it, but here we are. All of it is a matter of record, one way or the other. But it's not for 60 days after the license issue that it all has to come together.
But there does have to be site control. And site control is supposed to happen at the time of the RFA2 filing. And
site control in the sense of ownership? Or?
Well, I think in this situation, there's not even a signed agreement that we've seen. I mean, we have requested this information. It's one thing to have it under control and to execute on it.
What provision of the statute are you?
It's a regulation, a site control regulation. I don't have it at my fingertips, but I can provide it to you in a letter.
That'd be fine. I'm sure we have it as well.
I might be able to provide it for you while we're still here.
But the statute surely does not require, okay, I've made my point, and I've asked my question, and it was somewhat rhetorical, but but it is an important touchstone.
I believe that it is an important, without question, we know what the statute says, but we also, a decision has to be made on a license. And there have been promises that have been made, but nothing has been consummated.
Yes, sir, but we're
At
not
this
awarding
point.
a license today. And
I
you know
understand that.
I know you know that.
I
and
do.
We know that.
Right, correct. So the practical implications of where we are today, if you had to rule on what you have in front of you, is there's one way in and there's one way out. And that place is Horizon Way, and that is in Boston. And there has been some briefing on this issue of what does that mean if there is access that is in one community that provides access to a development in a second community. And this has been briefed, I believe, by the WIN folks. And well, I think under the Gaming Act, it would be natural for you to look for supporting case law to help get guidance on how do you figure this out. It's a complex issue. Boston is saying that the only access point is in Boston, and that's the only way in. And yet the statute really doesn't directly address this, and there's no guidance with case law because the statute's new, and these issues have not arisen. But there is analogous property law, and this, after all, involves property, which deals with access. There are a line of cases decided by the Supreme Judicial Court, and I'll say them and give you the citations. We can also put it in a follow-up letter if that would be easier. Town of Brookline versus Co-Ray Realty Company, 326 Mass. 206, 1950. Harrison versus Building Inspector of Braintree, 350 Mass. 559, 1966. And Beal versus Planning Board of Rockland, 423 Mass. 690, 1996. These cases are analogous zoning cases that have bearing on the issue before you, and they basically stand for a simple rule, and that is if the access to a use is considered to be an extension of the use. Now let me put that in a different way because that may seem somewhat opaque. If private land in one city is used to provide access to a development in a second city, then the use of the land in the second city must be an allowed use in the first city where the access road is.
But those are zoning cases.
They are zoning cases.
This is not a zoning case.
But what this means is that in Boston, Boston does not recognize at this time casino gambling at the location where Horizon Way is. If that is the only access point to the casino, it takes on the use of the casino. Boston does not permit a casino use, which means that that road cannot be used.
Then the zoning board will deny a necessary permit. It doesn't spill over into awarding a license.
It doesn't spill into Everett, but what it says is that
No, it doesn't
Horizon
spill-
Way can't be used.
Doesn't spill over into a licensing decision. The licensee is still required to comply with, get all the permits from the zoning and planning board and everybody else. So it may be that there's a problem there. But it doesn't affect the licensing
The
decision.
licensee has to prove that they have access to the facility.
No question about
If
that.
the only access road cannot be used because of zoning purposes, then there is no access. So that is the legal issue. Now, Wynn has argued that that can't possibly be the case. There is a criminal case where the legislature enacted a statute that overrides a second statute of the legislature. Totally irrelevant. There is no conflict between the Supreme Judicial Court opinions and the Gaming Act. They don't collide at all. They simply have to do with whether or not the land can be used. The site control regulation is 205 CMR 119.01, Section 41. But in addition, what we do know from the Wynn application that even if the projected road that they would like to be able to use were used, they need permitting in Boston. They need curb cuts. They need to widen roads in Boston to make left-hand turns into that. Even the drawings that we've seen, that our experts have analyzed, show that property in Boston has to be taken for the road to be able to provide the adequate safety access. In addition, the draft environmental report indicates that there are, they call it substantial off-site roadway improvements. It's Boston's view that the permitting, the access, the changes that need to be made are inextricably linked to the front door of the proposed casino. And they're part of it. They cannot be considered to be separate. Let me now turn to and that's why there is land in Boston, and Boston provides the only access, which is why Boston's a host community, if in fact there is a valid gaming establishment. Let me turn to the amenities, and I'll be brief because I think we've talked about this in the prior discussion. WIN's RFA 2 indicates that it has some significant amenities that are located in Boston. It's identified 2 of them, and I mentioned to you earlier that these types of non-gaming amenities are big revenue generators for the applicant. And in this case, TD Garden and the Boston Symphony Hall, BSO, are defined, or they're included in section 415 of the RFA 2, and they're called gaming establishment of high caliber with quality amenities in partnership with local facilities. And WIN's quote on its discussion about the TD Garden and Boston Symphony is as follows. First of all, we know they're non-gaming structures. WIN's strategy is not to compete with existing sports and entertainment venues in the region. The goal is to feed them. This is why WIN has partnered with TD Garden, the Boston Symphony Orchestra, and other iconic locations to serve as its de facto sporting and entertainment locations. Section 33-33 at 104 of the RFA 2. And it's clear that these amenities, the TD Garden and the Symphony, are directly related to the gaming area. They're going to serve the patrons. This is the whole WIN image. This is a Boston casino, not an Everett casino. That's how it's going to be promoted. We are going to have strategic partnership alliances with well-known venues, structures in Boston.
Isn't that what the statute's designed to do? I mean, how do they, the statute is full of injunctions to reach out and lift all boats and get everybody involved in this, make strategic partnership. All of the slots parlor applicants did that. The slots licensee had, I think, by the time we awarded the license, some 60 cross-marketing agreements with places including Gillette Stadium. That was all designed to fulfill the statutory objective.
Well, the cross-marketing point, obviously the statute encourages that, and it's a good thing.
Because the statute is designed to promote jobs and
absolutely.
employment and
There's
more
no question
revenue
that,
in there. If you can get people into I thought that the statute was designed, if you can get people in here to go to the BSO, get people in here to go to the BSO and do a little gambling while they're here.
no doubt about it. These are partnerships. They're not simply supporting local arrangements. As I mentioned in my prior remarks, when you fill the TD Garden because of an entertainer, a celebrity, a well-known performer, and you put thousands of people in the seat, that is far and it generates tremendous revenue, the bulk of your revenue. We're not talking about a small percentage, and we're not talking about helping out the little guy. We are talking about these partnerships generating significant revenue for the applicant.
You know, I've looked at the financials. They are not revenue generators. They are actually liability. They work the other way. The applicant actually enters into an agreement by which they promise to bring some of their clients. But move on. Let's move on to your next point.
Well, it's our view that these types of partnerships, these two, and our amenities, and they're located in Boston. There's one other point that I want to make, and I know I've used probably well more than my time, and I thank you for graciously listening to me. The water shuttle that has been proposed, it's an access point. It is an access point projected to about 3% of the people that are going to be visiting the casino. It begins in Everett. It will cross Boston waters, but it is an exclusive shuttle to Boston venues only. That, too, is an amenity for the patrons. Here's where the locations of the water shuttle are. The USS Constitution, the TD Bank Garden, North End, Faneuil Hall, the Aquarium, Financial District, Seaport Innovation District, and Logan Airport. None of these venues are in Everett. They're all in Boston. This is an attempt, according to Wynn, to connect its patrons with historical, cultural, and entertainment attractions in Boston. And while we feel that that also, that the dredging and everything that is going to happen, we've had some experts looking at this issue. We haven't completed the analysis, which is costly. We believe that part of the former Monsanto site, which is submerged, is going to have to be dredged for this in Boston for this to work. In any event, we believe that the shuttle, the TD Garden, the partnership arrangement with the BSO are amenities located in Boston. We believe that the access, the only access that you have before you, other than conjecture and hypothetical situations, is in Boston. But more fundamentally, I don't think you have a gaming establishment, period. You don't have a valid agreement for one. You can't find FBT Everett to be suitable, and that agreement with them is null and void. It violates public policy. So all these other issues really are superlative at that point. You don't even need to reach them if you address directly the issue of the land agreement.
All right, Mr. Frangillo, thank you, sir. All right, now the Wynn interests have an opportunity to be heard. I want to say something before you actually start, though. But if you want to take your place, that's fine. Oh, you're going to sit there?
They need the mics.
There's no Eastie.
Pardon me?
No further presentation from no Eastie.
I'm sorry. Did you want to speak again?
We'll take a couple minutes, sure.
Oh no, take the time you want. That was my bad.
We will. I actually thought that the cadence was City of Boston.
Yeah.
We'll go whenever you like.
Yeah. I'm going to ask you to go next, please. And the essence of your remarks was heard last time, but I would like you to hear them. And I'll explain why in a second. But
Thank you for this opportunity to speak on this issue, and we'll only take a few minutes. You know, Attorney Frangillo pointed out in kind of the crux of his argument that Verizon Way is the only point of access. I'll submit to you that it's much more than that. It's a funnel. It's a funnel, and the access points will be coming multiple-fold through the city of Boston, from 93 North, from 93 South. So to say that, or to get the perception that that one tiny access point is inconsequential, it's kind of the key to the whole equation. And again, it would rely on the city of Boston to a great deal for host amenities, for resources and services and the like. Now, the other element that he touched on is the arrangement that Wynn and even other developers plan to have with points of interest throughout the city. Now, we all know that those relationships will be reciprocal. As much as it's an amenity to folks that are guests at the casino, it will also be a draw to folks that are already funneling through into the city of Boston to spend their tourism dollars. You know, there will be notifications, there will be placards, there will be all kinds of marketing, cross-marketing, that folks will know, even if their intention is to maybe hit a show in the theater district. Oh, by the way, we can pick the shuttle up right here too. And that's going to be draining a lot of resources, financial and otherwise, from the city of Boston. And that further cements the indication that the city of Boston would be a host community for a Wynn Casino. I just want to take another minute just to veer a little bit off the beaten path. I think we know that I don't necessarily, I'm not necessarily right on with my talking points, but it struck me all the many days that I've come here and I have stared at your banner with the mission statement to introduce the Commonwealth to the successful and ethical development of expanded gaming. I would argue that my experience has been, and many within my organization and other organizations and developers and proponents alike, that we've kind of gone far off the beaten path of kind of the written roadmap. And I feel like we're at a juncture where we are desperately trying to successfully, to use that term loosely, install a casino in the first pass. This is our first try here in the Commonwealth of Massachusetts. We have pushed deadlines. We have let benchmarks go. We have ventured into really murky, uncharted waters in an attempt to successfully and ethically install a casino in Massachusetts. And, we've argued and submitted that the legislation and the language are guidelines to be interpreted by, developers, proponents, opponents, and certainly you commissioners. I don't know where, and maybe Matt can dig out the precise segments of the legislation that says a casino has to be installed in every region in the first pass, that we have to bend over backwards, slide deadlines, forego hitting high points and benchmarks, and make all manner of exceptions so that in the first pass, we have to install a casino in the Commonwealth. And I'd just like, you folks to think about that a little bit as you consider the applications, as you consider all the major gaps and loopholes and elements that are still missing from these applications. And that's all. Thank you.
All right, thank you.
Very briefly, as this commission is aware, we're a volunteer organization. Our focus has been in our backyard in East Boston. Certainly have been following the Wynn application with interest. Like perhaps some others in this room, I own a small piece of Boston, about 1,000 square feet of it. I'm a taxpayer. I drive in the city of Boston. I live almost entirely all of my life at this point in the city of Boston. And I'm very concerned about what's happening at our borders, literally at our borders. Attorney Frangillo has already beautifully covered, the issues that most concern us, especially as to the suitability of this application. But I do just want to touch on the fact that, as has been stated, that these applicants are relying upon the city of Boston to market, to promote, and to maintain this casino. That is the entire purpose of it. I'd just like to read into the record very briefly a blog post posted by by one of several AstroTurf groups supporting the Everett Casino.
Wait a minute, this is a what?
A blog post, a weblog. This is dated April 28th. I won't read the whole thing, but it exclusively mentions, and it mentions, I will be fair, sites all over Massachusetts, but it focuses on sites such as the MFA.
Wait a minute, I'm not sure of the context for
This is a promotional campaign.
And who published it?
This is an associate of the Wynn. It's called Everett United.
What's the entity?
Everett United, and they're
Everett?
Everett United. They're a paid,
Everett United.
Right.
Okay. So
a paid promotional group.
All right. Well,
and they're
I don't
promoting.
know that, but
Okay.
Go ahead.
I don't have to read too much of it, and it's easily findable. But they're promoting this project, and again, this is just one of many, many comments in this direction that can be found, and were cited in our brief directly, that have come before this commission, in fact. They're promoting Boston sports teams. They're promoting the MFA. They're promoting Massachusetts' reputation as a medical center. They actually mentioned Saudi sheiks coming in for appendectomies. And those are all things that we're very proud of. The problem is that all of these things are being marketed, promoted, and put out into the public without our consent. And all we're asking is for the opportunity to have that consent. I live in East Boston, but I think the voters of Charlestown certainly should have the opportunity to say something about their reputations, and certainly their backyards being entangled with this project. Now, I mentioned last time I live about 3 miles from the Suffolk Downs site. I live about 5 miles from the Everett site as Mr. Wynn's helicopter flies, and I would very much like to see a casino-free Boston. That's why I got into this, and the name of our group certainly suggests that we're concerned about East Boston.
Right.
But we are concerned for all of Region A. Now, I happen to believe that the Supreme Judicial Court is about to allow a repeal question on the ballot in November. That's my opinion. The argument was just heard earlier this week. And I'm sorry to say that I think that the Revere project, the Suffolk Downs project, pardon me, will be Exhibit A, and that this project will be Exhibit B when that repeal question goes in front of the voters. Not through any fault of this commission necessarily. I think it's really just a fault of the law, which is short-sighted, hastily drafted, and put through at the last possible opportunity. Now, again, I understand that's not what we're here to talk about. Very quickly, what we've been discussing at this entry point, which I think is absolutely crucial, and as it is for the Suffolk Downs project as well, because how you get to a place certainly has everything to do with how it's going to operate. Essentially, the city of Everett is asking the city of Boston for an easement. That's what I would say. More so than a zoning question, this seems like it's an easement. They're asking, do you mind if several thousand people drive across your already crowded highways, your already crowded land? And I think that of course, anytime you ask for an easement, you actually have to go through that process and ask the landowner if they mind having it driven over. And we're just here to say that the city of Boston should have that opportunity. And I'm not going to expand any more on the incredible work that the legal team has already done in their research and their presentation, but that's what we have to say.
All right, thank you both very much, as always.
Thank you.
Now, before we start, let me say that one of probably the primary reason we set out the process that we set out, the process for exchange of briefs, was so that nobody would be caught by surprise with respect to things that were made at these hearings. This is an extremely important part of the process. And it's one in which a lot of interests are at stake. And so that's why we set out the process that we did. We varied from that process to invite the city of Boston to come and present arguments, even though it hadn't filed a brief, believing that the arguments it was about to make, or would likely make, were arguments that were well known. With respect to the last argument, I must say that I heard some things for the first time that I hadn't thought about, at least in that context in which they were put. It may be that you heard things for the first time, at least in a context that you hadn't thought about. And so if you need some time, reasonably short time, to respond in writing to things that were said, I'm inclined, with my colleagues' consent, if they agree, to give you that time. You don't have to decide that this minute, but I would like to have you decide it before these proceedings adjourn. So with that, I'll turn it over to you, Mr. Weld, or Mr. Starr, whoever's going to commence. All right.
Thank you, Commissioner McHugh, and like you, I believe in notice and process. I made that point last week.
You did.
And I respect greatly your decision to allow the city of Boston to make their presentation today. They chose not to present a brief on April 17th. They chose not to file a reply brief on April 24th. What they did send you on April 17th was a criticism of your process. But we are prepared today to go forward with our presentation. We did hear a few things for the first time. And what I'm going to do is divide the presentation, commissioners, between myself and my colleague, Mr. Weld, my partner. I will try and answer the question which I thought we were here today, which is the location of the gaming establishment. I thought that's what we were here today to do, and that's what I'll answer. And Mr. Weld will pick up on some of Mr. Frangello's preliminary remarks in his first 25 minutes. I'll pick up on the back end of it. We have a PowerPoint today. Jenny, does the commission have a copy as well? I think each of you have a copy of it. Thanks. Also, I would note, commissioners, that at council table with me is Mr. DeSalvio, who, as you know, is Senior Vice President of Development from Wynn Resorts, and also Dan Gatewood, my partner, and my colleague Jenny McCarthy, who I will rely on to make sure that the slideshow goes correctly, because I don't have the competence to do that. So we're here today to present on the premises of Wynn's proposed gaming establishment. And this is the question that you asked us to address when you issued your procedures early in April. Determine the premises of the gaming establishment for which Wynn Mass LLC seeks approval in its December 31st, 2013 RFA2 application. In response to this question, we submitted a memo on April 17th. We attached to the memo the affidavits of Attorney Gatewood, of Attorney Crum, and Attorney McCarthy, all of which had attachments to them. Those affidavits included what we thought were the pertinent pages from the RFA2 application, although we appreciate that you took note in your original order that you were going to take note of the application, so we didn't have to give it back to you, but we clipped some pages to the affidavits that we thought were relevant and important, and we also attached some pertinent correspondence, as well as some key parts of the transcript from September 4th, whereas Commissioner McHugh has mentioned, you first took up this issue, and we gave the chronology from after September 4th, and I don't intend to use my time today going through that chronology. It's set out in the brief. I think it's important, but you have it there. Instead, in answering the question presented, we start our analysis with the Gaming Act, because that's where we believe a proper answer to the question will be found. And the Gaming Act, and in particular the critical definitions. The most critical definition is what we're here for today. The gaming establishment. First and foremost, the premises approved under a gaming license, which includes a gaming area and any other non-gaming structure related to the gaming area, and may include, but shall not be limited to, hotels, restaurants, or other amenities. There are two other definitions that I think are related. I think one of them, Commissioner McHugh, you read earlier in your introductory remarks, the definition of a host community. It's a municipality in which a gaming establishment is located, or in which an applicant has proposed locating a gaming establishment. But there's a second definition, which is also critical here, because we heard an enormous amount in the last 50 minutes about access. It's the word I heard a lot from the last 2 or 3 speakers. Surrounding communities, municipalities in proximity to a host community, which the Commission determines experience or are likely to experience impacts from the development or operation of a gaming establishment, including municipalities from which the transportation infrastructure provides ready access to an existing or proposed gaming establishment. As demonstrated from Wynn's site plan, which is presented in answer to question 4-79 in the application and the accompanying attachments, Wynn's entire gaming establishment is located in Everett. On the next slide, you'll see this is our answer, Wynn's answer to 4-79. I apologize that the print is quite small, but this identifies the project site, which is entirely located in Everett. And then we attached a conceptual site plan. And this is the conceptual site plan included in our application. We showed it to the Commission at the September 4th, 2013 hearing. As I said, we included it in our application. It has been provided to Boston, and it is unchanged. This shows our gaming establishment and our gaming establishment site are totally in Everett. We also included in our RFA the 1942 land court plan showing the boundary of Parcel B. Parcel B, which is the parcel on which Wynn's gaming establishment will be located, has existed in its current configuration since at least 1942. And on the next slide, what I did was I simply turned the slide, turned the plan, so that Parcel B is oriented in the same way that I think you're used to seeing it, and as it will appear in the next several slides as we begin to show you where on parcel B we have located our gaming establishment. So turning from the RFA itself to several graphics which I've created to clearly illustrate the location of the gaming establishment on parcel B in Everett, I show you this slide. And I ask you to take careful note here of the city of Everett, Boston boundary line, which clearly separates parcel B and parcel C. The parcel boundary, which is right there, this is the parcel boundary, and it's also the municipal boundary, right along here. My red pointer is showing it. And that's a critical boundary to keep in mind as we go forward. On the next slide, we show you Wynn's Gaming Establishment site, which is the land on which the gaming establishment is located. This is an important place to pause. I'm going to use two terms here, gaming establishment and gaming establishment site. As we set forth in our pre-hearing memo, the gaming establishment site is an area greater than the gaming establishment itself. And I would refer you to page 6 of our memo. I want to read from page 6 of our memo, where we drew the Commission's attention to this. Our interpretation is supported by the Commission's use of a different term, quote, gaming establishment site, to describe an area greater than the gaming establishment in the RFA2 application. And we provide a couple examples for that. First, question 4-4 of the RFA2 application asks, and I quote, provide a color rendering of the gaming establishment and all structures located on the gaming establishment site. And I've attached that as Exhibit 14 to the McCarthy affidavit. And then question 4.4-11 of the application asks a similar question. Describe the restaurants, retail spaces, bars, lounges, and other non-dash gaming amenities located within the boundaries of the gaming establishment site, along with the names of their proposed operators. For Wynn, the Commission's use of the term gaming establishment site in the RFA2 application evidence the Commission's intent to distinguish between the broader term gaming establishment site, which includes the land owned by the applicant upon which it proposes to build its gaming establishment, and the more narrow term, the gaming establishment, which includes the gaming area and other non-gaming structures related to the gaming area. And remember, we're asked today to determine the premises of the gaming establishment. So if we could turn to the next slide, please. Let's focus now on the gaming establishment itself. We're going to turn our attention from the gaming establishment site to the gaming establishment. I read this definition earlier. It's the gaming establishment is the premises approved under a gaming license, which includes a gaming area and any other non-gaming structure related to the gaming area, and may include but shall not be limited to hotels, restaurants, or other amenities. It's right from the statute. Now, the word premises, as we noted in our memo, is not defined in the Gaming Act. We suggested a couple possible definitions for the word premises. Of course, we have Webster's Collegiate Dictionary definition, the premises being a building and the land it is on. Another definition might be the definition you'd find in normal real estate parlance. The word premises or leased premises is used to describe the actual space within a building leased to a tenant, whereas mortgage premises is used to describe the real property pledged to secure an obligation. But from Wynn's perspective, we think looking at the plain and unambiguous language of the statute, the correct definition is the premises of the gaming establishment is meant to include the gaming area and all other non-gaming structures related to the gaming area. And for Wynn, The gaming area and all other non-gaming structures related to the gaming area will include our gaming area, our hotel, our restaurants, our bars and lounges, the nightclubs, the retail spaces, the spas, the meeting, and the convention spaces. That, for Wynn, is the gaming area and the other non-gaming structures. And I'm going to use some graphics now to illustrate exactly where these components fit on the gaming establishment site. This next slide shows the entire gaming establishment site, and in yellow, it shows the location of the gaming establishment on that site, all of which is in Everett. Now, obviously, because of how this slide is, you can see the City of Boston boundary line and so forth. Please don't misinterpret what I'm saying here, okay? The gaming establishment site is parcel B, which is a subset of that slide. But so that you have context, I included, obviously, where the City of Boston and the City of Everett come together, and you'll see, once again, as I showed before, the property line, which is also the municipal boundary line. The yellow in there is the location of the gaming establishment on that site. Next slide, please. Now we're going to start to break it down and show you the components of our gaming establishment piece by piece. I'm going to show you a series of slides that illustrate these components of Wynn's gaming establishment as defined under the Act and the location of these components on the gaming establishment site. The first step is to illustrate the gaming area. That's the first thing that the definition says, and here you can see in sort of a light shade of purple, that's the location of our gaming area. Next slide. In red, we have the location of the hotel. Because this is a slide of the second floor, it's over the gaming area. You no longer see on this slide the gaming area. Next slide, please. We've added the restaurants and the bars and the lounges, but of course, since we're now back on the first floor, you have the gaming area in the light purple color, and in the reddish color, you have the restaurants and the bars and so forth. Next slide, please. Now, we're still on the first floor. We've added to the gaming area and the restaurants, we've now added in the dark blue color, the retail areas. These would be the stores. Next slide, please. Still staying on the first floor, we add the back of the house plan. That's in gray, and it's in the upper right-hand corner, and there are a couple of elements to the left of the gaming area as well. And we return to the second floor to show the spa, which is located over the gaming area, and the restaurants. Also on the second floor in yellow, we add the convention space, which is a ballroom and a meeting room. And then this final slide of this series shows the second floor back of the house, including such things as service area, kitchen, laundry, etc. These last group of slides illustrate what Wynn believes to be the gaming establishment. It is all in Everett. But even if we proceed to add other non-structure amenities located on the gaming establishment site, it will not change the conclusion. It's all still in Everett. So, for example, if you chose a broader interpretation of the word premises to include non-structure amenities, that might add in our planned harbor walk, our planned docks, or our planned internal roadways. Wynn does not believe that this is the correct definition for a gaming establishment. But should the commission believe that you need to take these other non-gaming structures into account, it will not change the ultimate determination because all of that is solely in Everett. The next slide will illustrate that. Here we've added, as you can see, the dock in brown. It might be actually in white. The dock is here. We've added some internal roadways here. And we've added what we call on this slide, and it's really not a correct designation, it's called here an amphitheater, but it's really just some tiered outdoor seating in the grass. But as you can see, when you add these additional elements, you're still completely in Everett, and you're completely on the gaming establishment site in Everett. This next slide shows, from Wynn's perspective, the built-out gaming establishment site. And when you look at this slide, you can clearly see the municipal boundary line. I've put that in before to let you know it was coming. Here it is, the red boundary line. This is the municipal boundary line between Everett and the city of Boston. It's also the property line. And the gaming establishment is located on the gaming establishment site, and that is solely in Everett. So this slide shows in yellow what Wynn believes to be the gaming establishment site. Once again, the red line shows the municipal boundary line. The gaming establishment is solely in Everett. Now, turning to host community. The Act defines host community as a municipality in which a gaming establishment is located or in which an applicant has proposed locating a gaming establishment. Because Everett is the municipality in which Wynn has proposed locating its gaming establishment, Everett is the host community. In Noesty's reply brief, they made two arguments in their reply brief, and they, to some extent, reiterated them last Thursday and again today with respect to the Wynn Casino. First, Noesty argued that Horizon Way should be considered part of Wynn's gaming establishment site. And then secondly, they argued that it was inequitable for municipalities that are in very close proximity to a gaming establishment not to be deemed host communities. And I'll take each of those up in turn. First, let's talk about Horizon Way. Horizon Way is not part of Wynn's gaming establishment site. As a matter of law, Horizon Way cannot be part of Wynn's gaming establishment site because other abutters have rights to Horizon Way. Now let's be clear about what Horizon Way is and what it isn't. And we outlined this in our brief. And Jenny, you know, it may help the commission. I'll put back up another slide. If we could go to page 11, where you'll actually have a picture of Horizon Way. Okay, here's slide 11, and you can see Horizon Way right there. Now, Horizon Way is a public and private way that provides access to the Wynn site. It is approximately 400 feet long and about 50 feet wide. It is a public way where it begins at the intersection of Alfred in Boston, right there, and Broadway in Everett. And in fact, the Boston-Everett boundary line bisects Horizon Way right down the middle for the first about 150 feet, right where my pointer is there. All right, it starts right here, right where the two streets come together, and then it heads up in this way. The remaining 250 feet of Horizon Way is exclusively in Everett. And Horizon Way abuts the gaming establishment site in Everett, not in Boston. See, the Boston property line ends there, right there, and then the balance of it is all in Everett. Wynn does not and cannot control or own Horizon Way. It's a separate legal entity from the Wynn parcel. Other abutters, such as the MBTA, which owns property over here, they have rights in the way. Wynn can't change the legal character of Horizon Way. It's not Wynn's now, nor can it be. Horizon Way is a part public, part private way that provides ready access to Wynn's gaming establishment site. And if you turn, Jenny, back to slide 32, I highlight ready access, because those words aren't mine. Ready access comes right out of the definition of surrounding community. If we can look at the next slide. Surrounding communities, municipalities in proximity to a host community which the Commission determines experience or are likely to experience impacts from the development or operation of a gaming establishment, including municipalities from which the transportation infrastructure provides ready access to an existing or proposed gaming establishment. Horizon Way provides ready access to the Wynn site. Ready access confers surrounding community status. It does not confer host community status. Noesty's second argument?
But let me just break in here.
Sure.
You're not proposing to use that for access, if I understand you correctly, in any event. Is that right or wrong?
Horizon Way?
Horizon Way.
In the application, and this was previewed at the hearing in September,
I know, but that September was a long time ago, and, yeah.
there are the preferred access would not be through Horizon Way.
Right.
But that would be through the completion of a series of transactions and agreements on properties in Everett, including with the MBTA. And if that is successful, that would be the access, and Horizon Way, you're absolutely right, would not be an access to the site. The only reason I bring this up to the Commission is that if we had everything in place, which we don't, but we are working toward it, if we had everything in place, then of course our access would be completely in Everett, and the City of Boston and Noesty would not be able to advance this argument. So I address the argument because that's the one they advance. They advance the Horizon Way argument. But it's of no matter to what we're talking about today, because access is not siting of the gaming establishment. Access goes to surrounding community. So even if we were to examine the Wynn application through the lens of access from Horizon Way, it doesn't change the conclusion that the Wynn gaming establishment premises are in Everett. Boston may appropriately be a surrounding community because of its proximity and because Horizon Way, which starts in both Boston and Everett, but as I said before, it quickly becomes exclusively in Everett, and that's where it ultimately reaches our site. The second argument that Noesty advanced was the proximity argument. And as I understood their argument, they said because it's so close to the border, then it must be a host community. And I would suggest to the Commission that if the legislature, which drafted an extremely comprehensive plan, had intended for communities that were very close to a gaming establishment to be host communities, the Gaming Act would reflect that. It doesn't. The Gaming Act and regulations establish an extensive process for mitigation of significant impacts to surrounding communities. And proximity is a factor in that analysis. Proximity confers surrounding community status, not host status. Now, last week at the hearing, Noesty's counsel made a statement, and I have the transcript here, and I apologize, it's hard to read, but I want to read the quote, the first part of it. And what counsel said was, but host community status isn't about necessarily the structures. It isn't about the buildings. It isn't about all that other stuff. It's about the people who live there and how they are going to be affected. But the problem with that passionate argument is it ignores the plain language of the definitions set forth for host community in the Gaming Act and the regulations. Let's take a look at those definitions again. Chapter 23K, Section 2, host community, a municipality in which a gaming establishment is located or in which an applicant has proposed locating a gaming establishment. Wynn is not proposing to locate its gaming establishment in Boston. It is proposing to locate its gaming establishment in Everett. And the Commission's regulations actually provide some reiteration of the definition from the Act. Host community, and I'm reading from 205 CMR 123.01, host community is a municipality in which a gaming establishment is located or in which an applicant has proposed locating a gaming establishment. That's very similar to the statutory definition, but more language is added. Provided, however, that if a proposed gaming establishment is situated in 2 or more cities or towns, each shall be a host community for purposes of Chapter 23K. The additional language clearly reinforces that the critical factor is where the gaming establishment is located or situated. And in our case, the gaming establishment is located or situated in Everett, not in Boston. In summary, the location of the proposed gaming establishment determines host community establishment. The gaming establishment includes the gaming area, buildings, and structures, and Wynn's proposed gaming establishment is located in Everett. Now, Mr. Frangello, as I said at my introductory remarks, had a couple of comments which I'd like to address, and then when I'm done with my presentation, my partner, Mr. Weld, will address the balance of it. One of the things he said, he focused on, was that I think he said 65% of the revenues were from amenities, as if to say that the Boston Garden and the BSO all of a sudden is contributing 65% of the revenues. Now, what the application said was that at the Wynn Las Vegas facility, Wynn generates 60% of its total revenue from non-gaming sources. Now, non-gaming sources are all inside the building. They're all located at the site. That's Wynn's hotel. It's Wynn's dining facilities. It's Wynn's retail facilities. It's Wynn's meeting facilities. This is not the case where in Las Vegas, for example, if Wynn decided to buy some tickets at the Performing Arts Center known in Las Vegas, I believe it's known as the Smith Performing Arts Center. If Wynn chose to buy some tickets for a guest to go attend there, that's not Wynn revenue, that's a cost to Wynn. Similarly, exactly as you pointed out, Commissioner Zuniga, this is not a source of revenue for Wynn, it's a cost. These are not revenue generators for the applicant, they actually cost us money. And we did attach to the Crum affidavit, and I apologize for taking time on something which I think is so quickly dismissed. And Commissioner McHugh, you were exactly on point. The Act, I think your word was, I can't remember your word, encourages, but you had an even better word for it. The Act encourages applicants such as Wynn to enter into these types of cross-marketing agreements to promote businesses at places like the BSO and at the TD Garden. These are cross-marketing agreements. They're exactly what Wynn did. We are encouraged to do that. And in our brief, we attached the BSO arrangement, the letter of intent. This is what Wynn agreed to do. Wynn will be a Chairman's Circle sponsor for the December 12, 2013 company Christmas at the Pops. Wynn will host a reception for BSO artists and other participants following the performance by Keith Lockhart and the Boston Pops Esplanade Orchestra at the Smith Center in Las Vegas on November 17, 2013. Subject to obtaining a license to develop the project, Wynn will sponsor the 2014 Christmas at the Pops. Subject to obtaining a license to develop the project, Wynn will sponsor the 2015 Christmas at the Pops. We attached a letter from the TD Garden. The TD Garden sent a letter to Catherine Blue, General Counsel. Please be advised that in December 2013, Delaware North Companies entered into a sponsorship agreement with Wynn, pursuant to which Wynn sponsored the 2013 Boston Bruins Holiday Toy Drive. The Garden and Wynn are independent contractors, and neither party has any ownership interest or control over the other party. Mr. Frangillo also said one way in and one way out, and that is in Boston. That's not true. I've shown you the slide. Horizon Way, if he was talking about Horizon Way, abuts the property in Everett. It starts in both Everett and Boston at that intersection. The boundary line bisects the road, and then after about 150 feet, it is exclusively in Everett. We did receive yesterday from General Counsel Blue a request to address certain matters, and I appreciate that email, and I'd like to read it so that you can see why I'm now addressing this. This was sent yesterday afternoon to my client. The third paragraph of the email reads, "At tomorrow's commission hearing regarding the determination of the premises of the gaming establishment for which applicant seeks approval, representatives of the applicant should be prepared to discuss any option agreements held by the applicant or any applicant affiliate for property located in the city of Boston and how those options may or may not relate to the premises of the proposed gaming establishment." So with that in mind, I want to show you the next slide. Now on this slide, well, it should have been in green. It doesn't show quite as well, but in any event, here is Wynn's gaming establishment site. Here's parcel B. And then we have parcel C in red right there. And then the TEV Realty Trust parcel. Those two sort of pinkish brown shaded parcels are under option to a Wynn affiliate, and they are located in Boston. For completeness, although General Counsel Blue didn't ask, I've also included two parcels in yellow, which are completely in Everett, on which Wynn affiliate, is it Wynn? No, the applicant. The Wynn itself, the applicant, has an option on those two in yellow. These two here in reddish, the reddish brown, they're under option to a Wynn affiliate, and they are located in Boston. Now, let me tell you a little bit about each one, again, responding directly to what General Counsel Blue asked. First, I'll focus on parcel B. And I will remind you that Wynn provided information on parcel C at the September 4th, 2013 hearing. The owner of the property is FBT Everett Realty LLC, which is also the owner and seller of the gaming establishment site known as parcel B. Wynn controls, under an option agreement through a Wynn affiliate, Everett Property LLC. The purpose of this parcel? The parcel is owned by the owner and seller of the gaming establishment site, and like any prudent developer, Wynn believes it is prudent to control an immediately adjacent parcel. There are no structures, gaming or non-gaming, planned for this parcel. In fact, the parcel consists mostly of land underwater and a mudflat, so construction on the parcel is really not practical in any case. And I'll illustrate that, although you can see the text here, open water, edge of water. But let's go to the next slide so you get a sense of the water, okay? Virtually all of parcel C, 80% of it, is all the blue. That's all water. Likewise, a fair bit of parcel B is water as well. The boundary line is in the middle of the water. The second, while we leave that slide up, I'll provide the same information on the second parcel, which I've identified on the slide as TEV Realty Trust. Wynn controls this through an option agreement through a Wynn affiliate, Everett Property LLC. This option agreement was entered into in January of 2014. Wynn believes, as with the other parcel, it is prudent to control property immediately abutting the existing right-of-way which could provide access to the gaming establishment site. There are no structures, gaming or non-gaming, planned for this parcel. I believe currently there is an unused vacant building on the parcel. Jenny, if we could turn to the next slide. Actually, before I close with this, I'm reminded that Mr. Frangello did bring up the Beal case. That was the case where he talked about access. I once again have to commend Commissioner McHugh. I'm not sure that I could do a better job distinguishing the case than I believe you did in your questioning. We briefed that case because we anticipated, based on a letter they had sent in March, that it might be raised. It's fully addressed in our brief, but in summary, Boston's argument fails for 3 reasons. As Commissioner McHugh pointed out, it's a zoning case. Also, critically, in Beal, the developer was creating a new private road and therefore needed planning board approval. Here, unlike Beal, Horizon Way, if that's what the City of Boston is pointing to, is an existing road, and the only approval required from Boston to expand the way, if any, is approval from the Public Improvements Commission, which does not have general zoning authority. And we also point out that the legislature is presumed to be aware of the prior state of the law, and therefore we believe the well-drafted Gaming Act in this instance would trump the Beal case. So the question that I thought we were answering today was to determine the premises of the gaming establishment for which Wynn Mass LLC seeks approval in its December 31, 2013 RFA2 application. As I hope you will conclude from my presentation and our memo and the affidavits, Wynn's entire gaming establishment is located in Everett. Therefore, Everett is the only host community. And I'll close with the slide again. Here, once again, in yellow, is the location of Wynn's gaming establishment. That proposed gaming establishment is located solely in Everett and not in Boston. And I would ask Mr. Weld now to address Mr. Frangello's preliminary remarks.
All right, thank you, Mr. Starr. Mr. Weld?
Thank you, Commissioner. Mr. Frangillo referred to 2 hearings held in 2013 by the Commission. One, I believe, was on September 4th and the other on December 13th. I was present and acted as counsel for Wynn on both of those occasions, so I'd just like to address those 2 hearings and the issues that they involved. The September 4th hearing was held to address very much the same question as is on the agenda today, namely the location of the premises of the Wynn proposal, which determines the question of host community. Counsel for the City of Boston at that occasion demonstrated what she called some images of the project on which certain land located in the City of Boston have been shaded in green, and suggested or intimated that this indicated that land in the City of Boston was part of the project. Commissioner Zuniga correctly asked her, was it the city's position that artists' renderings or early marketing materials would take precedence over the actual application? The city said, no, of course not. And the upshot of that hearing was that the then suggestion by the City of Boston that it was entitled to host community status kind of fell away of its own weight, with some encouragement from the Commission that the parties go out and try to get on the same page on this. And from that point on, the discussion was about surrounding community status for Boston and the benefits attendant on that. A lot of the same verbiage argument was heard there about ready access, and that's fine, but that's relevant to surrounding community status, not to host community status. And we went over that ground again and again at that hearing. I don't think at that hearing the arguments that the TD Garden and BSO marketing arrangements made them amenities within sufficient to suggest that Boston should be host community status. But in addition to the point that the amenities have to be on the premises, I think the implication of your question, Commissioner McHugh, about Section 15.3 suggests that, well, let me put it this way, it would be hard even for Steve Wynn and Wynn Resorts to acquire Boston Garden and the Boston Symphony Hall within 60 days of receiving a license. So I think that's another statutory implication that makes that argument fall away. The other hearing was on December 13th, more or less, 2013, and at that hearing we did address the sellers issue, sellers of land issue, and around that time the Commission, on the basis of exhaustive proceedings, appropriately found applicant Wynn to be suitable and found all the people who needed under the statute to be found suitable to be suitable. The Commission did hold hearings on whether a procedure worked out by Wynn with respect to the sellers of land was appropriate, and that was essentially to reduce the purchase price for the land from, I believe it was $75 million, down to an amount that would approximate fair market value. And I believe that value was testified to by our Wynn's expert to be $35 million, perhaps less, $10 million for costs of remediation, so that the casino premium, the Commission, I think, found that the casino premium had been squeezed out of the commercial transaction between Wynn and the sellers of the land. The Commission did have certain requirements which we've been working diligently to satisfy, and I'm confident that long before the Commission is at the license stage here, all of those requirements will have been met to the satisfaction of the Commission. There's a couple of ways in which that could be done, and we're working on the easiest way first, and I think we'll be successful there. But if that's not successful for whatever reason, then we'll proceed to a slightly more time-consuming method of doing that. But I think that will be laid to rest as well. If the Commissioners have any other questions about what happened at either of those two hearings, I'm happy to test my recollection.
No, I have no questions. I have a distinct recollection that at the second hearing, there was a straightforward way laid out to deal with the FBT issue, and that straightforward way remains in effect. So I know effort and focus is being placed on.
Oh yeah, no, the straightforward way is what I was just referring to as the easiest way.
Right.
Literal compliance with.
All right. All right. Any questions for Mr. Weld? No questions. All right. That concludes the presentations. Then thank you very much. Let me.
Commissioner McHugh.
I'm sorry.
Yeah.
Mr. Starr.
Well, he's probably going to address
I'm
that.
sorry. I'm sorry.
It was this relative to, we gave them the option to respond to what we heard here today that you hadn't before. Is that, do you want to address that?
Commissioner Zinnig. No. It's exactly what I was going to ask, what the process was for me to have a chance to speak with my client and then let the Commission know if I'd like to take you up on that very kind offer to address a couple of the issues which we were hearing, at least in this context, for the first time this afternoon.
Well, all right. Then let me talk now among the four of us here, of course, so that you can see, about the next steps. And is your client available to make that kind of a decision immediately, or would you need time to make that decision, Mr. Starr?
We could make the decision promptly. If at a recess, we could certainly make that decision and then get right back to the Commission.
Okay. So here is a proposal that I have. I've been thinking about process and how we move forward from here. We have had anticipated making this decision a week ago. we didn't for reasons that are now neither here nor there. We have had presentations by all of the parties here today, and it's a good thing that Mr. Frangetta talked about a discussion. That's the level at which this ought to be, and we're grateful for the continued participation, thoughtful participation from No East to Casino. Delighted that the city is here. Got good presentations from the applicants. The time has come, it seems to me, for a decision. On the other hand, and this is a modest qualifier, it seems to me that the thoughtful arguments that have been presented by all sides require a thoughtful written response. So what I would propose, subject to your thoughts, is that we make a decision in principle here today, and that we follow that decision in principle with a written decision. We have a meeting a week from now, in which we spell out and formally approve the decision in principle with a more extended statement of the reasons for it next week. And that at the same time, next week, we take up the question of whether to waive the requirement that the arbitration and negotiation clock starts ticking the moment we issue that decision, because that's a matter of independent concern for me. I'm not sure which way I ultimately come out on that, which way we'll all come out on that, but I would like to discuss that issue next week when we decide the matter formally. So I simply start the discussion by throwing that out as a proposal to see what the thought is about that.
So you're suggesting some type of preliminary ruling on the two questions before us about the definition of the gaming establishment with a more formal report to be approved by us a week from today?
Yes, really a decision in principle today, an outcome and the basic structure of the reasons for the outcome, and then a formal written decision next week. And I suggest that because otherwise it is very difficult in this open meeting context to draft a decision and get everybody's input so that it's conceivable if we don't do it that way, we come here next week with a draft thoughtfully prepared by the staff, as they always do, but as to which we have a variety of disagreements, and we can't do it. So if they have a target to shoot at, I think we're much more likely to get the formal decision done next week, but everybody will know today what it is.
Where does the, Commissioner, where does the decision by the applicant and whether or not they want to respond in writing fit into your scenario?
Well, if that is, I would suggest we take a recess. We need a recess anyway. And give them time to decide whether they want to reply, and if they want to reply, we can adjust the schedule slightly in order to get that reply.
Okay, so we'll recess.
That would be the proposal.
That's fine by me.
I'm okay with it.
Consensus is that's the way
Yes.
we're planning to go? All right, so we'll take this time. I know the hour is late, but I do think we need to move this forward at this stage. So we'll take a 10-minute recess and then resume.
Thank you.
All right, I'd like to resume the hearing now, please. Bring this to a conclusion. It's been a long day for everybody. I'm grateful for everybody's patience and participation. Mr. Starr.
Thank you, Commissioner McHugh, for the opportunity to speak with my client, and we have conferred, and we are pleased to go forward with the hearing this afternoon, and we do not need any additional time to provide additional information. We thank the commissioners for making that offer, but we're all set.
All right, Mr. Starr, thank you. Now, I neglected before to extend the same offer to Mohegan Sun. Mr. Conroy, I asked Attorney Grossman to tell you that was an oversight on my part and extend the same offer to you.
Thank you, Commissioner. We will also waive the opportunity to file anything additional and ask you to go ahead as well. Thank you for the opportunity, Commissioner.
So the discussion that we propose to have then is a discussion in which we talk about the essential points as we see them, based on the briefs, on the materials that were presented here today, the oral argument, the oral presentations, I should say, outline a basis in principle for a decision, make that decision and vote on it. The vote will be a preliminary but binding vote, and then ask staff to draft a statement that incorporates the principles in greater detail so that there is a more formal written decision. Bring that back to the commission for ratification, really, next Thursday at our regularly scheduled meeting, and then discuss at the same time whether the clock starts ticking, if there needs to be a clock ticking. That will depend on the decision itself. So with that as an outline, who wants to begin?
Are we starting with Mohegan?
Well, we can
or
start
Wynn,
with,
or-
let's start with Mohegan, since you suggested that.
Because I was,
Well, they went first.
because then I would cede that opportunity for someone else, to someone else.
All
I
right?
don't mind
All
starting.
right, go ahead.
Okay, so I spent a lot of time with our legal staff, really making sure I understood the issues, making sure I understood the definitions, listened very closely today to everyone's point of views. Spending a lot of time in public safety, I know that a good attorney will make the argument, no matter what that is. But there were a lot of good points made today. I think really the crux of this whole matter is what is that gaming establishment? And I do believe the definition is pretty clear, and it is in the, which community is that gaming establishment? And I'm convinced after listening to everyone's arguments today that Mohegan Sun's gaming establishment is in Revere. I think that one piece in the lease was confusing. That has been removed, which I'm also persuaded that that Suffolk Downs will be running the track, will be operating, owning the track, and not Mohegan Sun. I agree with Noesti. I agree with the City of Boston. There are lots of impacts for the City of Boston, a great amount of impacts, but I believe those can be handled in a surrounding community agreement, and that is mandated before we issue a license, and we expect that to happen, of course. So those are my comments on Mohegan and where their establishment is located.
All right, that is the thrust of the issue before us. Mr. Zuniga?
Yeah, I agree. I think there's a lot of factors already outlined in the presentations. The ownership is different. The lease provides for only those premises to be leased that are in Revere. Mohegan is not leasing any of the premises that pertain to the track, for example. I'm persuaded by the presentation. I also had thought about the determination that this commission has relative to structures that are related to gaming establishment, which would then constitute an amenity. I view that part of the statute as a decision we have that could be motivated by our need to, or desire to have jurisdiction over those premises, whether it's for safety, security or safety reasons. And in this case, that we already have jurisdiction over the track, so long as Suffolk Downs continues to be a racing licensee. So for those reasons, I am convinced by the presentation here by the applicant, and I believe the gaming establishment to be like they describe it in Revere.
Mr. Stebbins?
I also, as Commissioner Cameron pointed out, looked at the definition of the gaming establishment, and the key terminology within that definition is really what we are authorized to license. A gaming license, not a racing license, but a gaming license. You know, I was understood the information presented, understood the information, you know, the comments from the city of Revere that this entire facility, this gaming establishment, will be within the city boundaries, regardless of how close in proximity, and we know it is, and certainly I agree with Commissioner Cameron's point about the fact that the city of Boston will be impacted. And that is the crux of why the legislation put in the provisions to protect surrounding communities. The issue was raised, I believe, by, and I just want to address it as a point that, you know, the representatives from the Noesti group, with respect to our seeming to rush to make a license award. I think this commission has always been mindful of the language to say that we could license up to one. And at some point in the process, we may find that the applications that are before us are not worthy of receiving the license. But it is a process that continues to play itself out. There are new details that we review. There's clarification questions that we ask of our applicants as we go forward. There's testimony that we take from residents in both the host communities and the surrounding communities. So with that in mind, I think this commission remains aware of our responsibilities, that we're moving a process along. You know, it's funny, sometimes they say we're moving too slow, other times we say we're moving too fast. But I think we're still trying to be thorough throughout this application process, again, with the ultimate decision of whether we actually award one or not. But I, too, also find that Mohegan Sun, Massachusetts application for a gaming establishment does reside and fit within the boundaries of the city of Revere.
I start with the proposition that we're bound by the legislative definitions. I think we all agree with that. And it seems to me that as much as that's reinforced, it sometimes is obscured, at least even for me and for other members of the commission, I think. And so it's useful to go back and remember what they are. A gaming establishment, that's what we're here to decide today. A gaming establishment is the premises approved under a gaming license, which includes a gaming area and any other non-gaming structure related to the gaming area, and may include but shall not be limited to hotels, restaurants, and other amenities. In this context, the definitional focus on amenities, for me, has to refer to amenities, structures, things that enhance the value of the main structure, the casino, and are under the casino's control. Section 15.3 requires the applicant to own or acquire within 60 days after a license has been awarded the land where the gaming establishment is proposed to be constructed. So if you can't acquire or don't have any intent to acquire the land where the amenities, which are by definition part of the gaming establishment, are located, it's not part of the gaming establishment. And that is particularly important in the case of the Mohegan Sun application, because it is clearly taking advantage of the landlord's racetrack. But the landlord controls the racetrack. Mohegan Sun controls the gaming facility. And striking from the lease the operating provisions make sure that that stays the same. The commission can also ensure that that stays the same, and that's not just a fig leaf. That is to ensure that there is independent operation and independent thinking about the two properties. It's clear that a landlord can take advantage of and participate in the profits of the tenant and lessee. That's common in many commercial agreements. But the tenant does not get to control the landlord's operation. So it seems to me that that is something that the commission needs to think about and ensure is perpetuated. Then, once you get to those definitions and apply those definitions to the facts, the host community is a municipality in which a gaming establishment is located or in which the applicant has proposed locating a gaming establishment. Now that one is one that has been, I think, obscured in some of the arguments that we've heard. It is true that these are designed to be regional facilities, but the legislature, in its wisdom, defined the host community in geographical terms, not in impact terms. Defined surrounding communities in impact terms. Defined host communities in geographical terms. And it didn't say that the gaming establishment had to have a 100-foot or a 1-mile setback into the host community. It didn't set any setback requirements. It simply said that the host community is the community in which the gaming establishment is located. A different statute would have had a different result. But this is the statute that the legislature passed. This is the statute that we're bound by. This is the statute that we have to work with. And that was something that the legislature obviously and carefully considered. So it seems to me that when one looks at the definition of what a gaming establishment is, looks at it in the context of the ownership requirements, I might add the registration requirements, because the statute provides that employees of a gaming establishment have to be registered with the commission. And then looks at the host community. The Mohegan Sun gaming establishment is located exclusively in Revere. And so that's how I too would decide that issue. All right. Let's turn then to the Wynn application.
Okay, I'll start again.
Sure.
Again, listening closely to everyone's comments, everyone's arguments here today, I'd like to start by saying I continue to be concerned about the land deal. As I share the concern of our Director of Investigations, but I do look at that as a separate matter, one that has yet to be resolved. We're not licensing today. We are here to determine the gaming establishment, so I do see a separation with those two. And with regard to the gaming establishment, I was not convinced with the argument that cross-marketing agreements and the usage of facilities in Boston or transportation in Boston then leads us to believe they are amenities and part of the gaming establishment, and we've had those conversations. I know the primary access is not to come through Boston when it comes to the entrance to the Wynn facility, but I know the secondary option does, but I'm still not convinced that Horizon Way is part of the gaming establishment. I know we've been a lot of conversations about that, but I do not believe that would be part of the of the gaming establishment, and for the reasons I stated earlier, I am convinced that Wynn's gaming establishment is solely within Everett and not Boston, although again, tremendous impacts, and the proper way for those to be addressed would be through a surrounding community agreement.
I would, to discuss the Wynn gaming establishment, first of all, I appreciated seeing once again, the outline of the property. I, for one, would certainly consider the proposed amphitheater, docks, et cetera, that you own and manage is also part of the gaming establishment, is certainly an amenity. Your docks are going to be used to get people to and from the water shuttle up to the building, but that's my opinion. But again, all of those still reside within the boundaries of the city of Everett. Like Commissioner Cameron, I appreciate the city of Boston's concerns about suitability of the current property owners. But as we have always talked about, suitability is ongoing. And as you saw in our last review of the Category 2 applications, we had an update on suitability of all the applicant and their related parties prior to our final deliberation on their license applications. I know this is also where the city of Boston touched specifically on the amenities, and obviously they mentioned the relationship with TD Bank and with Boston Symphony Orchestra. I also, again, fall into the side of the argument with respect to these amenities. One, not only in the argument of the actual ownership of these facilities, but I do hearken back to the statute. As you get through the purposes of the statute, I believe in Section 1, after they talk about how the commission shall conduct itself and that we need to protect the lottery, the immediate next section relates to how these resort facilities need to have a positive impact on surrounding businesses. They need to maximize the assets, the cultural and social assets of the Commonwealth of Massachusetts. I think the legislature and the governor and this commission have always talked about the fact we do not want these facilities to be walled-off fortresses. And if that openness and that relationship with the community around it and the neighborhood around it is part of the requirement of the application, it's part of the priorities of the statute, I didn't think it was intended to necessarily have every amenity or location of an amenity be considered part of a host community. So with that, I also deem from the presentation and the arguments that the gaming establishment, as it meets the definition for the Wynn proposal, does fall within the property boundaries of the city of Everett.
Yep. I agree with all of that. I would put a fine point on the following. The suitability that we made, the determination of suitability on phase 1, which is ongoing, is one of Wynn, the applicant. I think that's very important to underscore. Also, Commissioner McHugh has already alluded through his questioning about control or ownership of the land. The statute gives 60 days after the award of the license. So, clearly the stand envisioned that there was no need for anybody to make a purchase up front in order to be able to compete in the evaluation of a license. So that's key to several of the arguments that Attorney Frangillo made. I guess we already made the point, but the cross-marketing agreements are costs. As I mentioned, liability. They are not by any stretch, they're the opposite of what was characterized as revenue generators. And they are very much in line and with the spirit and the letter of the statute relative to using the existing capital, the existing assets of the Commonwealth, not just the city of Boston. So I I'm persuaded by the arguments from Mr. Starr relative to the plans, the access. I don't believe that the existing Horizon Way constitutes any part of the gaming establishment as proposed, and I would therefore agree with my colleagues.
I said a number of things based on the definitions a minute ago in respect to the Mohegan Sun application. The same definitional pathway through this issue applies to Wynn, and I'm not going to repeat it all. I do put to one side, however, the FBT issue. My colleagues have said there remains a concern about that. But I put it to one side because we had a hearing on that. We came up with a remedy that reduced the price to what the owners of that property would be able to sell the property to anybody for. Now, obviously, one can differ with appraisers' appraisals. But the idea was, and that appraisal was a very, very thorough appraisal. But that appraisal was designed to look at what you could sell that property to a big box developer, like the developers who have used the adjacent parcel, or some other some other entity to use for, in a non-gaming context. So they come into the deal with an asset that they're prepared to sell to the Wynn interests, and they come in with an asset of that value before the casino premium takes over, and that's what they get. They don't get a casino premium, and that was the theory underlying that. We've referred that what we found to the very able, thoughtful, thorough law enforcement agencies. We referred it to the district attorney, the attorney general, and the U.S. attorney, and asked the Bureau, and the Bureau has cooperated, to the best of my knowledge, with all of them in whatever further inquiries and undertakings they want to take, they want to undergo. But the Bureau separated out that part of the deal from the suitability of Wynn. And why did they do that? Because suitability under our statute and regulations applies to those who are going to be involved in the operation of the gaming facility. These are sellers, vendors, one-time vendors. They don't, and they won't have an ongoing role in operation of the facility. So that I put to one side. I recognize the concern, but I put it to one side for that reason. Having put it to one side, I then go through that definitional matrix that I talked about before and focus, as my colleagues did, on the requirements of Section 15.3 that the applicant own or acquire within 60 days after the license is issued, the property on which they propose to build the gaming establishment. That's put in there for a purpose. Everybody who's applied, I think, for all of these licenses, with one possible exception, has had option deals that were contingent on getting a license. That was thoughtfully put into the statute to allow people to build a possible acquisition, a site, and then execute on the site and put up, in some cases, the hundreds of millions of dollars purchase of the site would take, not in this case, but in some cases, and not have to go out of pocket and speculate as an inducement for people to apply. That's a perfectly sound financial approach. And so that part means that the fact that the precise contours of all of the land that are included in the application have not yet been firmed up does not mean that the application is fatally flawed. So for all of those reasons, I conclude that the gaming establishment proposed by Wynn Mass LLC is in the city of Everett exclusively and not in the city of Boston. And that is the issue that we are here to decide. It follows as a consequence, I think, from both of those decisions that the city of Boston, which has contingently applied to be a surrounding community is a surrounding community with respect to both of those applications. All right, do we have any further business?
That sounds like an agreement in principle.
That
We don't
is
need
a
a
decision in principle. Those are the main points,
Decision.
main pillars on which the decision is based. As I say, the formal decision will be forthcoming. But I would like, if we have no further discussion, to take a vote to adopt that decision in principle and ask the staff to prepare a report for our approval at the next meeting that incorporates those points and that outcome.
So moved.
Second.
All in favor?
Aye.
The ayes have, the ayes have it unanimously.
Motion
All
to
right, do I
adjourn?
hear a motion to adjourn?
So moved.
All in favor? Aye.
Aye.
We're adjourned.